Yes.
May I have your lordship's leave to mention a review application? My lord, it is appearing in the list, my lord. It is your lordship has yes, item number 129, my lord. It was substantially heard on the previous occasion
Supplementary list.
on the supplementary list, my lord.
Yes, hand over the slip.
My lord, may it be fixed any date, my lord.
Please hand over the slip.
My lord, with your lordship mentioning motions, my lord, this is against unauthorized counsel. Just in
Motions, please hand over the slip.
May I have a motion, my lord?
State motion, please hand over the slip.
here on various occasions.
Please hand over the slip. Please wait. Extension of interim order, please hand over the slip indicating when it is expiring. Upgradation, please hand over the slip indicating the urgency.
My lord,
Yes.
Restoration application.
Applications, please hand over the
my lord,
slip.
may I have a lordship's kind leave?
5 application. Cooperative.
Applications, madam, please hand over the slip. Yes.
My lord, may I have a lordship's kind leave? There is a cooperative matter, my lord, for inclusion.
Under which heading?
My lord, hearing, but my lord, kindly have a look at this order. Kindly, for my satisfaction, my lord, kindly have a look at this order. Dada, lord, kindly have a look at paragraph number 3. That is all I am seeking for, my lord. Paragraph number 3, my lord. Lord, just a direction to appoint a special officer so that my flat can be registered, my lord. That is it, my lord. Nothing else.
Hand over the slip indicating the
Much
urgency.
appreciated.
I am permitted to mention for inclusion in the list for hearing.
Hearing, please wait.
So,
Yes.
or my lord, contested application.
Please wait, please wait.
My lord,
Contested application, hearing is the same thing. Yes.
The language is different. matter.
Language is only different.
May I have
Yes.
a lordship can leave to mention the item number 491 of the monthly list of the
For upgradation,
for upgradation.
please hand over the slip indicating the urgency.
Urgency already pleaded urgency, but that
My lord, may I be permitted to mention a matter, my lord? New motion matter, my lord, there is some urgency. This, my lord,
Hand over the
my lord, the
slip.
writ petition I am challenging.
Hand over the slip indicating the
My lord,
urgency.
this is very urgent matter. My lord, I have mentioned in the mentioning, my lord, in the presentation form that regarding urgency, day after two more matter may be listed. Some urgency is there. But I pleaded that urgency.
I'm mentioning this better for upgradation. I'm old age lady.
Motion.
Yes, 80 years. My lord.
Indicate the urgency.
Yes.
Yes. Call the list.
Get full details.
I appear for the petitioner, lordship.
Now for the rest, opposite party.
It appeared in the
25.
list, but none of you appeared, but there was a mistake in the number.
It appeared in the
Lordship.
list.
It appeared on 5th. It appeared on 5th, but with a wrong number. Year was wrongly mentioned, thereby the cost title was also wrong.
Yes.
Cost title was wrong.
Ah,
That
that
is
is why I'm
why
saying.
Because
I was about to ask my man that why? What were they doing?
Because it appeared, but with a wrong cost title. So thereafter it was detected. So when do you want? Because
Any day. Huh? Oh, the correction is possibly required to be made. My lord, last order it has become CO 1971 of 2025.
25.
It would be 2023.
for that the mistake was for that. Because on the next day it also appeared under the heading of 2025. So the cost title
cost
also got changed.
The cost title of that matter.
Ashun. It has been pointed Sorry for the inconvenience because the year was.
That's it.
I was also apprehending why none of the parties were appearing. Thereafter, it was pointed out that went to the wrong number. Yes.
I will.
I was supposed to file. Oh, okay.
You are supposed to file.
The written notes.
All of us, not the petitioner.
You
It
are
was
prepared.
kept for that purpose. Worship, this is my written notes.
Mr. Chatterjee, how many pages? 15 pages.
No. I think, my lord, only 5-6 pages.
6 pages written notes with a 3-page written writ petition. 6-page written notes.
My lord, my English is bad, my lord. It carries on, my lord.
4-page writ petition.
No, it's a telegraph.
6-page written notes.
My lord, it's a telegraph English, not a statesman English. That's so difficult. My lord, only one thing, my lord, I just indicate the judgments which we have cited. My lord, we have not annexed with the written notes.
You have not taken back the copies of the judgments?
No.
Perhaps.
This is lying in the file.
My lord, my learned junior has done one thing that I must indicate. My lord, this court, he recently got one same line, a judgment. My lord, if that can
By the coordinate bench.
Yes,
Want to rely upon a
same,
court?
yes.
Please give a copy.
Worship, I know that I was that matter. I
Then include
appeared.
that in the. Please
That is
include
there
that
in-
in the notes.
Yes. That is there in the notes. I must just
Please stitch it along with that.
Yes,
Otherwise,
I
it
must-
will file it. I'm recording that in a file. The written notes of argument filed by the learned.
Or I am appealing for the petitioner. I'm filing this appeal of service.
Only one matter, one thing, Mr. Chatterjee, and in those matters in coordinate bench decisions, any appeal carried from
My lord,
those
in
matters?
one matter, he told me there is an appeal, but it has not been moved yet. In one matter.
Worship,
That way.
the initial judgment relied upon by Mr. Banerjee, senior Mr. Banerjee, Radharaman construction, that order has been complied with. No appeal has been preferred. In one matter, but in this matter, Mr. Chatterjee, no appeal has been preferred. In another matter, appeal has been prepared. It has appearing in the list, but it
Not,
was not moved.
moved yet.
Why are you not getting it settled?
Because
Otherwise,
the appeal was preferred by the state, not by the corporation.
then I can do one thing. I can also relegate this to the division bench.
But
Once for all, it can be decided because
no, my lord, problem is my tenure would be ending in August. So, my lord, if it goes in that,
you can pursue the division bench.
my lord passes an order. Well, I'm sure, my lord, division bench is waiting for something to come from single. I'm sure.
I'm appealing for the petitioner, my lord. Using this appeal of service. Already extension of interim order, my lord. And see, last order dated 27th August 2025.
Yes, Mr. Bandyopadhyay. Oh, this is that matter where certain
Yes.
provisions- Mr. Bandyopadhyay, what do you say to this?
My lord, I sought for instruction, but till date, my lord, I have received. But
Because,
my
because
contention
in
is
the-
this, my lord, he taken leaves. And with consent to operate, my lord, he has, my lord, running the brick field. And my lord, it appears from paragraph number 3 that he is, my lord, extracting the earth. That is the silt. Silt is not the, my lord, the property of the landowner or the riot. As per section 3, minor minerals concessions, development, 57.
But Mr. Bandyopadhyay, have you gone through this judgment 70 to Calcutta?
No, my lord, I could not, my lord. Your lordship, my lord, fixed another date, my lord. On that,
Because,
my lord, I shall come with, my lord, better instruction, my lord.
Because those provisions have been declared to be ultra vires.
But, my lord, in one case, my lord, Bipin Bihari Mukherjee versus State of West Bengal, 1977, CHN 897.
Yes.
But it held, my lord, silt used for brick making is earth, and therefore a minor minerals within the meaning of section 3 of the Mines and Minerals Regulation Development Act 1957. substance deposited in the river, the fluvial action of the river, if in the river if declared as minor mineral, would be vested in the state for extraction such mines and mineral surface would be mining operation. He is operating the mining operation, my lord. The petitioner being not a riot, provision of the West Bengal and the rules of cannot be given effect. But in
Mr.
respect of the land in question, my lord, the respondents shall proceed with the accordance with the provision of the minor and minerals rules, my lord. But I have not, my lord, prepared.
Only one thing, 72 Calcutta was considered in that judgment.
My lord, I could not go through this, my lord. I
No,
could not
in
go.
that judgment you are relying, no, you are relying upon a judgment.
My lord, judgment is not with me, my
Oh,
lord. I
only
could not, my
some
lord. I only
extract you
reference, my lord, I have mentioned before your lordship.
when do you want? When do you want?
1 week, my lord. 1 week time will be given, my lord. I shall come with, my lord. I could not, my lord, prepare myself, my lord.
Please prepare, because this is an issue which has
My
to
lord,
be
my
considered.
lord. But he is not coming in this purview, my lord. That is for a 1 year to 2 year, my lord. That is stuck down, my lord.
But it is the private land, not on the
Whatever may be, but the Honorable Supreme Court has held, my lord, in this matter.
I have also some.
Mine,
Item number 4, my lord, I will prepare for the petitioner.
Yes.
Lord, affidavit of service, confirmed service of, my lord. Your lordship,
Service,
confirmed service, my lord.
confirmed service. Yes.
My lord, on Saturday only, the concerned respondents, my lord, the oil marketing companies 2, 3, and 4. I'm appearing for 2, 3, and 4. They have received the copy of the petition, my lord. Let my learned friend submit, my lord.
What is this matter?
My lord, acquisition proceeding under the Petroleum and Mineral Pipelines Act. My lord, under the statute, my lord, if a landowner has objection, he will give objection, and that has to be decided. My lord, I had submitted the objection. They had called for a hearing. Now they have not passed any order, and what they are doing, they are proceeding. My lord, that they cannot, my lord. Without passing an order, my lord, they cannot proceed with the proceeding. My lord would kindly.
My lord, probably subject to my lord's kind consideration, my lord, probably this is not the right instructions, my lord, because of the fact, my lord, the hearing was conducted, the petitioner was present, there's a signed on the order sheet.
No, he said he was present, but where is the decision?
My lord, the order is also been passed, my lord. He was, my lord, he has signed on the orders, my lord.
I have not been
My
supplied.
lord,
That is my specific
copy of the order.
my lord, I will supply, my lord.
You will be supplying now.
No, my lord, the orders they have taken, my lord, from the office, but my lord, I don't know, I don't have an acknowledgement because
taken from the office.
Yes, my lord, my lord, my lord, kindly sees the last page of this particular sheet, my lord, where his attendance is also there.
Yes, my lord, I have said that.
Yes,
But
my lord, my lord.
My specific case is that, my lord, no order has been passed.
My lord, the order has been passed. And
next paragraph 9 of my writ petition. 8 and 9, I have said that I have attended the hearing and no order has been passed. Paragraph 10, my lord, specifically I say that I am been running from pillar to post and we are unaware of the fate of the personal hearing that has been done.
My lord, the 3-1 notification subject to correction has been on 2023. Thereafter, the 6-1 notification has come up on 2024. And my lord, we are
Mr. Banerjee, you paid for diversion of that line from.
Yes, yes.
That prayer has been rejected in 2023.
2023,
My
my lord.
lord, that has not been.
And you will be, they have said you will be entitled to compensation. That's
Yes.
as per the law.
Yes,
My
my
lord,
lord.
that is true, but my lord, they have to serve me an order. My lord, kindly takes paragraph 9
That
and 10.
please serve him a copy.
My lord, then if I am aggrieved by this order, my lord, then I shall take.
It's before the
My lord, will
statute.
kindly record that, my lord, my grievance.
Today it has been served. Yes. The The next matter.
Break for the petitioner. I'm paying for 1 week accommodation because this
matter. No, on the same issue, the matter was moved on the higher occasion. They have suppressed this matter. Now, my lord, this is not maintainable at all. Kindly see the order of the earlier read court. On the same.
they have suppressed everything.
Entire suppressed.
Absolutely in unclean hands, they have come before.
On the same prayer, same. They have suppressed entire thing in the writ petition.
Yes. Have you disclosed this?
No.
No.
No whisper.
I'm not properly briefed. I'm not properly briefed on this
Who
matter.
has briefed you? Where is the advocate on record? You are the advocate on record.
Oh,
Who is the advocate on record?
Advocate Devdeep Mondal. Mr.
Where is
Devdeep
he?
Mondal is out of Kolkata. Out of Calcutta, so I am paying for 1 week
Out of
accommodation.
Kolkata. Ask him to join online. He can join online if he is out, even if he is out of Calcutta. Please ask him to join online. 12.
At 12.
Yes. Ask him to join either physically or online at 12. Mr. Border Sumater. Six.
Same issue.
State led by Ms. Jhuma Chakraborty Lordship.
Yes.
I am appearing for state, my lord, in this matter.
Yes.
I'm paying for a 1 week accommodation. Same issue, of course. You know, 5 and 6 is the same issue.
Why are you praying for adjournment?
The
Why are you praying for adjournment?
the AOR is same on.
Maybe AOR is same. You are the arguing counsel. Who will argue, AOR or the arguing counsel? Please start. Yes. Please start.
Yeah.
Yes, what is your instruction?
Lordship, I have no instruction, but kindly see the representation, Lordship, annexed to P1, page 15.
Yes. Have you served upon the private respondents?
No, so in this matter, the service has not yet been complete.
The learned advocate appeal. Under the heading motion. The state is represented by its learned advocate.
Yes. I am appearing with the petitioner.
Led by Vimal Kumar Sahi.
Led by?
Vimal Kumar Sahi.
Yes.
I appear on behalf of the private respondent.
Yes.
Lordship, Lordship, only fact is that Lordship, petitioner made a representation before the authority concerned, alleging that the private respondent encroaching the PWD roads land in front of the petitioner land. That representation is considered in action, file a present writ petition. During pendency of the writ petition, already authority issued a notice
for demarcation.
For demarcation.
My lord, I am appearing on behalf of the state, my lord.
It was issued on
30th of January.
Lordship.
Yes.
Only praying for direction to complete the proceeding within a specific time limit.
Representation can be considered, Lordship, according
My lord, within the four corner of the writ petition, there is no indication that government land, PWD land in plot number 715. That is the allegation of the petitioner. Neither in the representation nor in the writ petition. Nothing disclosed about the government land in plot number 715, indicating that it is the PWD land. Nothing evidence is available.
You have not encroached upon the PWD.
No, my lord. Partly, I am in Rayat land, my lord.
You are in the
Temporary structure, my lord.
No
Temporary.
difficulty.
Deeply obliged. In this matter, I am the petitioner, my lord.
Yes, I beg to appear for the
Service served, all served.
Yes,
All right, file it in court.
I beg to appear for the
Yes.
private respondent.
Dated 28 March 2025, passed my lord Justice Honorable Rai regarding removal of unauthorized encroachment. The demarcation already done, unauthorized encroachment already detected. Then the assistant engineer, page my lord 28, I see for a moment.
Page 28.
Yes. Passed an order and forwarded before the subdivisional officer, that is pending. My lord, only direction conclude the proceeding within certain period.
Encroachment has not been removed within the time.
No.
Yes.
There are 3 stages in the order. The BLR will demarcate, then forward to the assistant engineer. Assistant we will conclude the hearing upon all the process. Then he will forward to the SDO. That is in the order. That is second stage, is not third stage. Not forwarded to the SDO. Number 1. So it is premature, not in position.
No.
And then kindly come to page number
PLR
26.
given his report, on the basis of that, he came to a finding. So I cannot say anything more. Kindly see the third paragraph.
The executive magistrate has to take a decision.
In the proceeding, he can take all points.
Then 3.
Yes.
If the removal
Only
is
10-1 stage is there. But then kindly see page number 26.
Mr. Jana, have you encroached?
No, kindly see page number 26, it will clear. Page number 26. Well, there are 8 encroachers. Out of them, 1 is the petitioner himself, 2 and 3 is his brothers. They are not implicated party here. And he himself encroached the land.
His encroachment will also be demolished.
No, he has removed. Kindly see third paragraph.
That is statement, but not
demarcation report, last line. Prior to first
Which
hearing.
page, Mr. Banerjee?
Milord, page 28, the order.
Yes.
Kindly see, Milord, from bottom third paragraph.
Yes.
Last line.
Yes.
Prior to first hearing, the petitioner removed his encroachment. That was recorded. So we shall, whatever is there, we shall remove.
Yes. Conclude the proceedings.
Yes.
Time, my lord, I picked to appear.
Lord, I am for the resolution 128.
The prayer question. I made a mistake in the prayer question to lordship.
Then dismissed.
Only. And can be appreciated.
Yes, he is praying for dismissal.
No.
Not praying for dismissal. Yes, what do you want?
My lord,
What is the mistake?
mistake, my lord, annexure P6 I have written, it should be
P5.
annexure P6.
It should be P6. All right. Yes. What is this matter?
My lord, this is the second round of writ petition, my lord. Earlier,
What are you challenging?
not the order that appears at P6.
Page,
my lord.
P6, page 32.
32. Yes.
Lord, may I, before my learned friend submits your lordship, kindly see, the copy has been served upon me, not legible copy.
That even, my lord, I'll be
Your lordship,
kindly
kindly see that.
type copy or a legible copy. May I kindly adjourn for that. That is.
You should have seen it, man. Whenever you are giving the copies to us. It's
check.
really unfortunate. We have been also practicing for last 4 decades. Huh? This is.
Yes. How are you agreed with this?
My lord, kindly turns to page 10. Paragraph 18. I have specifically stated what is my case.
Page 10, paragraph 18. Yes.
Paragraph
What have you
18.
stated? What is your plot?
Oh, the plot I have mentioned 1723 to 937. Physically, that has been according. If your lordship kindly call for a report from the block land and land record officer as to whether my land has been utilized or not.
Yes.
Even the record of right says the 22 decimal of land which
Your
appears
property has been utilized.
Yes, my lord. That is my specific case. And my name appears in the.
It is not known to me, my lord, that's it. Today morning I have got the brief. Browsing over the read petition, I have seen the impugned order which is under challenge. That is not legible. What instruction I can have?
Please take instructions because
Somehow he has grabbed the property. My lord, the procedure you know better than me.
you have admitted that in the report. Please see this copy to that. That's admitted because
Somehow he has said, I was just going through the petition. I have seen grab the property.
yes,
If
that means you are without paying compensation. If you have utilized, that's grabbing.
We have
What's
to,
grabbing?
we have to ascertain.
To your own order. That's grabbing. Utilizing without paying compensation. What does it mean? Other than grabbing?
No, let me come back with the instruction first.
Yes, because there was a direct purchase policy.
There is there.
So if there is that means why do you want to purchase?
Let me have the instruction first, then I will come back. Your lordship can pass another.
Better copy. Why are you annexing these copies?
And it has become a habit, not paginating. Most of the petition I am seeing it. Most of the petitions. Not only in this court, in other courts also I am seeing the petitioners are not paginating the pages.
Yes, because this copy is a better copy. You should have given a better copy to.
I'll give a better copy or type copy, whatever.
Give a type copy. It's there.
Type copy, I'll give.
The petitioner
Or I am for the status matter, my lord.
Yes, Mr. Das.
This is my video service to go.
Divided, my lord.
My lord, petitioner is the resident of Purva Bardhaman, district Purva Bardhaman. In front of his house.
Public land eviction of unauthorized occupants
No,
Act 62 is not within my determination.
My lord, this is
For
not,
want of,
my lord, this is not unauthorized occupant act, my lord, this is Panchayat, my lord.
but he has captioned is under unauthorized occupants Act 62. I do not have
My lord, he has,
want of determination.
his grievance
Thing, but in the fair presentation form everywhere.
Then my lord divided to file
For
application.
want of determination.
Lordship.
The petitioner yes. Petitioner will be at liberty to yes.
This is the applicant of service.
Yes. Yes.
My land is being utilized. If your lordship takes up page 3 of my writ petition, paragraph 2. The Devottor estate.
Yes.
Having ownership in both this plot number 3366 and 3370 to the extent of 2 acres and 0.95 acres. I shall show before your lordship. Kindly takes up now paragraph 3. That your petitioner have noticed that for the purpose of construction of metal top road for linking the main road between Bardhaman Katwa Road to Bardhaman Shiuri Road via Palitpur, the property of the writ petitioner as described herein above has been
What
utilized.
happened? Why are you agreed?
Now, I do not know. No initiation of any proceeding, no compensation, nothing. My representation, my lord.
Your property has been utilized for the link road.
For the purpose of construction by PWD. Yes.
Link road.
Metal top road. Link road.
Yes, Mr. Bandhavat.
My lord, it has to be demarcated by the BLRO at the first position, my lord, and then we have to come out with a report from the PWD whether it has been utilized or not. But BLRO has not been made a party, my lord. It has...
Now, my lord, kindly takes up, my lord. I have in my representation, my lord, page 19, if your lordship takes up, representation starts, my lord, from page 17. Why I am not showing your lordship that, my lord, these two plot I am having, my lord, this area of ownership, but the utilization in respect of my plot is being restricted to 0.28 in one plot and 0.11 acre in another. So it's not the entirety I am claiming. Rest of the area has not been utilized.
How do you know that this part has been utilized?
See, it's for them, Milord, they have to recheck it. But nothing is being done. On the contrary, under the Right to Information Act, they have informed.
This link road has been constructed.
Yes.
It is their allegation, their land has been utilized, but how they have come to know, my lord, their land has been utilized, unless or until it is ascertained or demarcated by the bearer concerned, but we cannot, my lord, say.
Mr. Bandhapadhyay, only one thing, for the purpose of when you intend to construct a road, there must be a plan. The plan will say it will pass through which plots. So produce the plan. It will pass through which plot. There is no necessity to demarcation at the first.
First come with the report
from
PWD authority with a direction upon the bearer concerned to demarcate the land, whether their land has been utilized or not. And I shall file a report.
That can be the second stage, Mr. Bandhapadhyay, because there may be two things. One is the
LMF.
Yes, you have the map.
LMF.
So when you have the map will show which portion. The notification and other things also has to be there.
That should be, my lord.
And
at the time of demarcation, that should be, my lord, consulted with.
That's a different second stage. So if the first this notification and other things covers this plot, there is no necessity
His allegation, my lord, is this: the land acquisition proceeding has not been
For that it will show that the land acquisition for these plots
My lord,
has
page
been
32,
initiated.
your lordship, kindly turn to page 32. He has got an information from the special land acquisition collector.
Yes, what did the information?
It is not available, my lord. Therefore, my lord, it is whether this land has been utilized by the authority concerned. Then second step, my lord.
My representation disclosed that the map published by the Bardhaman Development Authority.
Bardhaman Development Authority is not the party respondent here.
I am not suggesting that. That Milord is clarifying the position that yes, that road has been constructed.
that?
Milord, that page 18, Milord, I have
1.8.
1.8. Milord, kindly takes up second paragraph.
No, where is the document, Mr. Mukherjee?
That has been published, Milord, available in internet. Now, Milord,
the internet you will be having the copy.
It is for them, Milord, even it is for them to.
Mr. Mukherjee, you are the petitioner.
Yes.
You are stating certain facts. Where are these documents?
Milord, that is there.
That will be the end of the matter.
That is there, Milord, but according to my
You are saying that that's available. You have come to know from that document. So where is the basis of this statement? Please show me that document.
That, Milord, I shall, Milord, let them, Milord, carry
You have
out.
annexed that document because that is the basis of your writ petition. Why have you not annexed that? That could have shortened this matter.
But even if then also, Milord, they will have to physically demarcate it. Map only show that it is the road is coming across my plot number.
Mukherjee, there are two aspects. If from that map, from the notification, it can be ascertained that how much portion that will be given.
No, that is not available. It's only, Milord, showing that the link road is passing through and across my, Milord, those two plot numbers. So ultimate physical demarcation has to be done by them. My land utilized, according to my own, Milord, calculation and measurement, I mentioned in my representation what area exactly you have utilized. And the Right to Information Act also, whatever query, Milord, I made, the reply suggests that he has not initiated any proceeding with regard to any land acquisition proceeding with regard to these two plot numbers. Now it is for them, Milord, to come and verify whether my contention is correct or not.
The petitioner alleges
Item number 12.
10th of March.
I'm for the petition. Will the service not completed? I extend the copy by service.
Service not complete. Yes, what is this matter?
Matter is that my land has been utilized for the purpose of construction of a road of the powerhouse. Kindly see the picture.
Yes, Mr. Bandyopadhyay is appearing.
Yes, yes. The others, because our track report is not.
Who is the other respondent? State Electricity Board transmission. I think it's the acquisition.
Yes, yes.
Mr. Bandyopadhyay is the answering respondent, Mr. Bandyopadhyay. Yes, what is your
Otherwise.
Their allegation is that on the basis of forced deed, the land has been transferred by the Panchayat Committee in favor of the transmission company.
Page 76.
And whether this is maintainable or not.
Page?
Page 76.
Yes.
What is the averment? What is the averment?
That is the project in my land.
Yes, what is your prayer?
Here, the kindly see there without giving the proceedings of the land acquisition. They
Yes, which paragraph they have said that with forced deed?
Paragraph 4, page 5. Thereafter, page 6, paragraph 6.
Yes, sir.
Yes, kindly see page. The memo has been issued by the BDO. The BDO transferred the land to the
That for that you have to take other steps. Writ petition is not maintainable.
one thing is my land is recorded in my.
But you have admitted that it has been transferred by way of a
The
deed.
fact, I am
So
not
take
suppressed.
steps for challenging that deed.
Because in the part of the river, others land has been
That I do not know. Please take steps.
And also in paragraph number 7, they have also stated this.
Yes.
Because
Paragraph 6, paragraph 6.
how the BDO transferred the land to the.
That is why you have to challenge this deed. How the BDO transfer that cannot be decided in a writ petition. What do you want? You want to withdraw?
With the liberty to
The petitioner. Pre-service taken on record. 13 yes. Yes.
I am for the petitioner, madam. May I pay your lordship?
Yes.
Kindly come to, kindly see page number 2. By the lordship, liberty granted earlier.
Yes.
High authority has been implicated and copy has been served. Therefore, madam, kindly come to page number 13. The lordship heard the matter in earlier occasion. The land loser 68 years, widow lady, is not getting the compensation. In spite of this memo of 2024 and submission of all the records, bank, passboy, Xerox, etc., nothing has yet been done. That's why this writ petition with the bona fide prayers as paid in page number 9.
My lord, initially, my lord, what my learned friend has shown, my lord, the compensation notice was calculated and it was intimated. Thereafter, my lord, we received certain objection. He posed as if he is the sole, my lord, claimant. But there are 6 total in total. So we have received my lord, complaints regarding that, and we had issued a notice, and it was scheduled to be on 21st. Thereafter, I do not, my lord, have the
Nothing information, nothing of the sort to the petitioner.
and kindly please report it. Not kindly produce the report also.
Compensation has been declared, awarded.
Yes, my lord,
In her name.
Thereafter, my lord, the objection was raised by because there were other claimants to that also. So, my lord, we had issued notice for hearing.
Could not pay the compensation amount.
Yes, my lord.
But no information, nothing of this.
My lord, he has received the notice also. Kindly see serial number 4 of that particular notice.
The petitioner herself is the recorded owner.
She is not the sole, my lord.
Please inform him, write a letter. What prevents you from writing a letter to him?
You have issued the notice in her name also. Kindly see that she has
What is
received.
the reason behind?
Oh, this
Serial
is the
number
notice,
4.
13th of January.
Yes, my lord. The hearing was supposed to be taken on 21st.
21st of January. What happened?
Thereafter, I have to take instruction. My lord. This much I have done, my lord.
Mr. Please give a copy of the notice.
Dear.
And also, report may I have, since nothing, no records has been
Could
submitted.
you attend the hearing?
Yes, he should.
I will direct you to communicate the date of hearing.
Yes, yes. The communication was done, but I do not know what
Date
actually happened on 21st.
date may can be fixed up here in now, by
না না
by
সেটা তো
lordship
21st
order.
হওয়ার কথা 21st হওয়ার কথা সেই 21st কি
21st of January it was fixed. So
she has received the notice also. Your lordship sees the initials are there, my lord, in the.
do you know what is the next date?
No,
So that
sorry.
The petitioner
added, my lord, after passing that order, my lord, since it is the prayer for assessment and my lord, release and pay, that can be ordered that thereafter within 4 weeks or 8 weeks, that can be release and pay the compensation.
Will approach the court. Yes.
That is benefit to my lord.
Yes.
Voting not after the petitioner.
I will prepare me. Mark of right.
Kindly see the last order. On last occasion, your lordship was pleased to direct me to add the persons in whose favor the wrongly the amount has been disbursed to add as a party. I have added them and served a notice, but all the notice have been returned.
With what endorsement? With what endorsement?
Address is moved.
Then what can be done? That's not good service. If the address is moved.
Makes sense.
Yes, now what can be done?
Well, let them provide me the address, but they have disbursed the compensation. So
How
they
can
could
they
have,
provide the address?
they could have the right address of the respondents in whose paper the
On the
amount has
basis
been
of the
disbursed.
record, it is found that it is, my lord, on the basis of the record, amount has been paid, and my lord, order has,
They have given
Lord,
them
kindly
the
come
amount.
to- kindly
order
come to
has
page
already been
39.
passed that, my lord, that should be recovered from them, and my lord.
Yes,
39 last
erroneously
paragraph.
paid to
They have
certain persons to the
already
petitioners.
observed that my amount has been wrongly disbursed. Whereas the land which was acquired is my land, but I am entitled to get the amount.
If the certain persons have been paid according to you, they are not entitled to it steps in accordance with
But
law.
that is their findings
Such a
also.
dispute cannot be decided here. Such a dispute cannot be decided here. This is under the National Highways Act.
That is
National Highways.
What is the mode of this dispute can be resolved how? Where is the provision? National Highways Act টা কোথায় দেখি? Yes, what is the provision?
3H4. Civil
3H.
Code. 4.
So now nothing can be done. It could have been referred to prior to this disbursing. If now it has been disbursed, your remedy lies elsewhere. Recovery of money from there.
Recovery of money.
Mr. Mahato, where is your report saying that we have paid to the, you have filed any report?
Page 39. They have passed a recent order.
Recent order has
In
been
the recent order is that been indicated?
My lord.
Where is that?
Page 39, last
Page
paragraph.
39.
What happens to this obligation? Just it, refund it. Basic enforcement of this obligation. You refund it to the government, not directly to me, and then from the government to me.
But I
The heirs of Biswajit Basu.
I am the wife of Vishwajit Basu, Dolly Ghosh. Vishwajit Basu died in 2022.
Mahato, you have yourself observed that it has been erroneously paid.
Yes, it is erroneously.
Then, and is to be refunded by them to the government. What steps have you taken to recover this money?
My lord.
It's your finding.
Yes.
So you have arrived at a finding that it was erroneously paid.
Erroneously paid.
Then you have to text us for recovery.
My lord.
Because they are the.
My lord, let there be direction upon the, my lord, the competent authority to recover the money. So some more time be given and the amount be paid to the, my lord, to the heirs of Mr. Bichoy Ghosh. Because we are binding by the order.
Yes. Yes, next.
I'm getting. I'm for the petitioner, my lord.
Yes.
Last occasion, your lordship directed to file the report. Lord, I do not know.
Yes, Mr. Bandyopadhyay. Where is the report?
I have come with the report, my lord.
You have come?
Yes.
Yes, yes, please. What does the report say?
Well, there is no obstruction in front of the petitioner's land. We will also kindly go through the report.
Have you given a copy of the report to him?
The total block, my lord, by way of constructing the high, my lord, 8 foot, 6 foot, 8 foot height wall. A total, my lord, it is not
Mr.
the.
Bandyopadhyay, this field inquiry was done after giving him a notice.
That I don't know, my lord. That I don't know, my lord.
So Bandyopadhyay, when you are undertaking a field inquiry,
One
why are
photograph is annexed, my lord, here with
one
photograph, my lord, last page. But it appears, my lord, there is no encroachment of the petitioner's land.
But you should have notified them.
If it is not done, my lord.
I do not know why, how and which manner they have filed this report. My lord, entire front part is, my lord, blocked. And my lord, highway authority, my lord, replied to the RTI, my lord, notice. My lord, they have not constructed it. It is not the guard wall. There is no necessary for, my lord, erecting the guard wall. It is the highway. If there is necessary, then my lord, highway authority will construct the, my lord, the wall. And how the Panchayat Samiti will erect this?
Who has erected this guard wall?
My lord, your lordship kindly see middle Milord, after 100 years. Both mandirs are situated
No,
in the lower elevation.
Mandirs and other
There
things
are-
were
thereafter, Milord.
situated.
Thereafter, both mandirs are situated at lower elevation and the road have been in existence for over 100 years. Local demand. Local residents express the need of guard wall to facilitate safe worship as the current arrangement possesses risk accidents. Action taken to fulfill the local demands. The Honorable MLA such and such, Milord, from Bidhayak Unnayan Prokolpo as follows. District authority has sanctioned the scheme and fixed implementation agency, the block development officer, Hoishchandrapur. Video memo number such and that. The guard wall was constructed to protect the Kali Mandir and the banyan tree as well as the road to provide safety of the general people. The Rayati land plotting road beyond the wall is diverted along with wall and ends at the main road on the northern side. There is no blockage of ingress and egress as the existing road.
No, what do you mean by this?
As already
Rayati
has been
land
the
plotting
petition as well.
road. The Rayati land plotting road beyond the wall is diverted along the wall.
Wall at the ends of
So
the
you have
main road.
diverted. How could you divert this?
Then Milord, may I complete, Milord?
Yes.
There is no blockage of ingress.
Maybe, but how could you divert this? According to
cannot
you,
be-
there may not be any
Well,
blockage. How could you divert this?
Yes, Milord. There is no blockage of ingress and egress of the existing roads has already higher than the petitioner's land by 5 feet before the construction of guard wall, and guard wall was constructed only protect the road. The 100 years of old Kali temple and banyan tree over the such, there is already an approach road is located behind the temple and such and such. My lord, thereafter, my lord, the photographs it appears petitioner's land. It ends, my lord, the guard wall.
My lord, property belongs to highway authority.
No,
If
no,
necessary, my lord, they will erect the guard wall. And my lord, without taking any prior permissions from the highway authority, my lord, how and which manner the video, my lord, has constructed this wall, guard wall.
দর্শক তো দেখছেন, দর্শক যা বলবেন তাই হবে।
Yes, there is an approach road. How are you affected by this? There is an approach road.
My lord, the petitioner's premises,
Yes.
that adjacent to the
Premises তো
highway,
থাকা
adjacent to the highway.
Where is the highway?
Where is the
It
highway?
is Chanchol highway.
কোথায় চাচলে?
Chanchol highway.
It does not appear to be so.
My lord, I have, my lord, kindly see paragraph 5. Paragraph 5.
প্যারাগ্রাফ 5 এ তো এসব লেখা থাকে না।
It is Chanchol highway.
কোথায় বলা যেতে চলে?
And my lord,
This
kindly see,
photograph, have you considered this photograph? This
kindly
photograph does not show that it's on the highway.
my lord, kindly see page 35. Highway authority has given reply. My lord, kindly see page 35. Page 35. Highway authority. Assistant engineer. Page 35.
বোকা বোকা সব মিশে।
No, highway authority is not on highway authority's land.
Milord,
Is outside the ROW of the government road. This
Well,
does not help you.
It is the highway, my
No,
lord,
no,
highways
page
land.
35. They have said, the highway authorities have said it's beyond the, outside the ROW of the.
And my lord, kindly see in reply to your notice, 15/5/2006 received. 2nd June 2025 to the undersigned RTI Act regarding Paka wall.
They have not constructed. They have said that no permission was also sought for, and they have also said that it's outside the ROW of the government road. So it's beyond their. They do not have any objection with regard to this.
My lord, adjacent to the highway, And without notice,
want,
my
you
lord,
can-
without notice, they have, my lord, inquired the matter and, my lord, prepare a report.
Yes, they have given a report.
Without, my lord, notice
What
to the
without
petitioner.
notice? The report of the block development of I'm coming after 5 days. Yes, call the next.
My letter, item number 5.
Yes.
For the bill on one day accommodation.
Yes.
Not
Why?
also advocate record is on this marriage ceremony. Kindly.
Marriage ceremony, Mr. Datta. What do you say?
No, I have nothing to say.
Tomorrow? Marriage will be over by tomorrow. It will be over. You will come tomorrow. One day for marriage ceremony, Mr.
This is last week, you know. Today he is not.
All right.
Like last.
শুধু not today করে।
Same
ওইটাকে ওই hand over this order, Mr. Datta, you have
Yes, sir.
ওটা ওনাকে দিয়ে দিন কালকে। Yes, call the next matter.
Same position.
Yes. 16.
Item number 16, my lord, I am appearing on behalf of the state respondent. Earlier occasion, there is a direction to for filing a report. And the report says, my lord, the land does not belong under the jurisdiction of the policy highway subdivision. It's under the Nodia Jila Parishad in page number. It's not, there is no paginated, my lord. In fourth page, it has been specifically written. It may be jurisdiction under Nodia Jila Parishad.
Yes. What do you say? If it is not within the PWD,
But in that even Malad Jila Parishad, subdivisional officer is the Malad competent authority.
Jila Parishad has been implemented.
No, my lord. Not implemented as party. Overall, my lord, the case has been filed under the Highways Act, where Jila Parishad has no jurisdiction.
Where is your representation?
Malad at page 20. The SDO is the ultimate authority, Malad, who will execute. Malad, even he has an independent power under Malad CFTC for
Please
invoking.
complete the Jila Parishad.
Yes.
The learned
My lord, I'm appearing for petitioner. On the last occasion, the respondent authorities were directed to file a report as to whether before taking possession of the petitioner's land, whether the respondent authority had complied with section 28 of PI of Railways Act of
Lordship, on the last occasion, your lordships had asked us to take instruction regarding this, whether there had been a compliance with 20H and 20, then no report was to be filed as per the order. Now, your lordship, when I took instructions, it fell from the authorities that at this stage, the 20A E notice has been passed. 20F compliance is undergoing. So 20F requires the authorities, the central government or the railway authority.
Take position then prior to that.
I bow down. I bow down. So
That is not being by the respondent authority. You have stated in your petition.
it's not by us. So, your lordship, till the compliance takes place, I have no issues if the injunction continues. Once the compliance is over, then your lordship, I shall file a vacating.
So I will record your submission that you will not take any possession pursuant to compliance of 20F and other
The
proceedings.
injunction is subsisting anyway, your lordship, so that can continue.
private respondent, I'm simply submitting, but the petitioner is owner, occupier of the
objection.
I am the owner. My name is there in the.
तो उसके favor में उनको दिखाना.
Petitioner has no reason to be aggrieved by the order. Lordship kindly comes to page 88 of the writ petition.
Page 88.
Yes. He simply an occupier. Land belongs to me, the property belongs to me.
Your name is there. Plot number?
Serial number 5395, Dokan, kindly.
Serial number 5395, Dokan.
Dokan, Chameli Ghosh, Krishnodev Ghosh, Kaberi Kongar.
Yes.
These are the private respondents.
Yes. So you are the recorded tenants.
I am the recorded tenants. I own the land. After the railway decided to take over, they have filed an application for mutation of their name. That has been rejected by the landed BLRO. They approached the ADM. It is already
there.
Order, my lord, we have preferred appeal. Lordship kindly comes to page 55. Sale deed.
Page
54, 55.
Yes.
At the 55 at the bottom.
Yes.
Claim plot does not match with the field verification. Petitioner does not possess the plot document produced. Do not match with the claim. So thereafter they filed a civil suit. They prayed for injunction. The learned trial court was pleased to refuse that injunction.
That's against you.
No, they filed
Yes, they filed against you.
against me.
Yes.
And that injunction has been turned down by the civil court also.
I'm not deciding the interstate rights between
Yes.
you and the petitioner.
In the writ court, lordship will not go into the facts.
Yes, I'm not going into those facts.
My humble submission is they are not the recorded tenants. We own the plot. My predecessor from the grandfather's time, I am holding the plot.
Yes, now I'm not
No,
going
I'm not
into that
together
issues,
with
but here
This writ is only to circumvent the order of the BLRO and to somehow lay claim on the compensation which at some future point in time may be granted, may be passed.
So it has become an notification and there is no objection taken.
सर को बोलिए.
Second, page 86.
87, 87.
देखे नहीं जमीन.
Sir, कोर्ट पे देख.
By virtue of a title deed at page 25.
25.
Yes. But lordship kindly sees the schedule at page 34.
Yes.
It is জেলা হাওড়া থানা সাচানসাচ মৌজা বুড়িখালী গ্রামের 364 নম্বর দাগের উপস্থিত দুইখানি দোকান ঘর
And kindly see it is 395.
Ramer, it's 364.
Yes. And the plot in question is 395.
Yes. What right do you have in 395?
My lord, my father-in-law had purchased this land.
Yes,
Thereafter,
it's
we are
364. The property is question is 395.
नहीं Fear पे
Because in 1995, RS, LR, everything has come.
my lord, I will have to take instruction. my
What
lord.
instructions you will take?
My lord, whether the tag
I will
number is-
vacate the injunction right now.
my lord, whether the tag number is
No.
correct or not, my lord, kindly give me
In the schedule, take steps for rectification. If in the schedule of the deed there is a wrong mentioning of that, take steps for rectification.
Kindly give me
On the
one
basis
day,
of
one
this,
day,
you
my
cannot maintain an order of injunction. Where is Mr. Chatterjee?
My lord, this is a changed brief, my lord.
Next,
My lord, instead of tomorrow, can it be kept day after?
day after tomorrow.
Article number 18.
Yes.
Yes. On the last occasion, my lords was kind enough to direct me to hand over some written instruction regarding his allegation. My lord, kindly see, my lord.
What is the allegation?
My lord, his allegation is that, my lord, that his name has been mutated and my lord, they are not, the authority actually, they are not allowed. They have not allowed the writ petitioner to make payment.
Khajna, to deposit
Khajna.
the khajna, yes.
So,
What
my
is the
lord, kindly
instruction?
see, my lord, they didn't apply. My lord, kindly
My
see.
lord, we have tried to
Apply for what?
For mutation.
His
After
name has
giving
not been
no,
mutated.
no. Well, kindly see.
mutation copy have been given as annexure.
Well, kindly see. This is the
Tax
BLR, my lord. The
my
concern of
petitioner name.
sir. এটা দেখুন আমি পড়ে যাচ্ছি। Neither the petitioner nor his mother, who executed the gift deed, has found to be a recorded riot first at any stage of the settlement of revenue records, stroke record of rights. Then, that as per section 22 of the West Bengal Land Reforms Act, only a riot shall be entitled to pay land revenue as per prescribed rate envisaged in section 23 of said act and the rules framed thereunder. That the said deed of gift on the strength of which instant petitioner claimed to have acquired title in this was executed in July 2001. Since then, no mutation petition has been found to be preferred before the jurisdictional BLR such and such or any such officer duly interested to do so for incorporating his name in the statutory revenue records or record enabling him to be entitled to submit khajna or land revenue before the Senate. That the petitioner always have the liberty to approach the office of the undersigned for effective redressal with regard to submit land revenue so that a calculation of land revenue in question along with area, if any, may be attained, examining requisite documents like to be read at the end of instant request or petition instruction. This is for well, now, well, the question comes up, I am not taking that point that it is not the this is not the because High Court has got no authority because the land tribunal has got the authority. I am not on that. In spite of that, my lord, I am saying let it approve.
Show me that it has been mutated in your name.
Yes.
In the revenue records.
My lord, the tax bill is there.
Kindly see
Where is the tax bill?
I have annexed, my lord.
Tax bill is at page 9.
Page
It is
9,
of the
kindly
municipality.
see for the municipal.
Municipality. Please show me that your name has been mutated in the revenue records.
No, my lord, that has been not
So
done.
if that is not done, it could not also have been mutated in the name, your name in the municipality. Could not have been mutated.
But my lord, the municipality have given the tax bill on my favor and I have.
That could not have been given. And if your allegation is that your name has not been mutated, you apply, I give you liberty to take steps for mutation in accordance with law that will be considered.
Deeply obliged, my lord.
Ashun.
But however, my lord, point to be taken, my lord, point. No, I am not. This is not the appropriate point. Otherwise, my lord, everybody will come up and my lord will
I'm
get.
not going into that. I am only giving the liberty to take steps in
Oh,
accordance with law. I'm not saying anything.
Yes, otherwise, my lord, it will be flooded because so many have
That I am conscious of that. For that I am. No, without going into that, whether it will be flooded or not, the order will be nullity because the court do not have jurisdiction. I'm much more concerned with that.
I know.
Ashun.
Item number 19.
And I am appearing on behalf of the petitioner, my lord.
Yes.
My lord, this is the under section 10 of the West Bengal Highways Act, my lord. My lord, representation dated 42. My lord, schedule of-
Ma'am, his state, my lord, led by Mr. Khalid. He is on his legs, my lord. Court number 16, my lord.
Private respondent served.
Yes, my lord. My lord, this is the affidavit of service.
Where is your
My
representation?
lord, page 42, my lord.
Page?
42, court 2, my lord.
Yes, what is your instruction?
Lord, I'm not able to collect instruction, my lord. I'm not able to collect instruction, my lord.
The petitioner claims to be the Call the next matter.
Lordship, Amit Kumar Pan is appearing on behalf of the ECL, but due to some medical emergencies, he has not come today.
Who is appearing?
Amit Kumar Pan. Lordship, kindly, Lordship, kindly fix this matter on Wednesday.
That your lordship
He
can.
might,
But
Lordship, Thursday.
that I am not opposing. Thursday, Friday, any day. But may I tell your lordship the facts in short? I want a direction from your lordship. Let them consider that direction and they'll come back.
What direction you want?
Your lordship, can you see the facts and what I am saying? Let them consider and let them come at their time. Sir, I am making the facts in short. In 75, government has acquisition the land.
In
75. 76.
Requisition Act 2 of 48. Yes.
date is important, 18/6/76, position handed over to ECL. This fact, date is necessary. Now, notification issued in 88.
41A.
41. Then you also filed that they have not made any award. They are
Notice lap.
Notice-
41A lap.
Now, we have filed a read dismissed and filed an appeal. Then you will also kindly look to the order dated 17th October 2012 in the report. Division bench, what is the direction of the division bench? The Eastern Coalfield Limited authorities are hereby directed to vacate the lands in question forthwith and make payment of adequate compensation in accordance with law to the original owners of the lands through the concerned land acquisition collector for the period under occupation. Against that law, they moved the Supreme Court. Now, what the Supreme Court said next day? We find no good reason to interfere with the order of the revision bench of the High Court. All the special petitions are accordingly dismissed.
2013 Act. 2013 Act.
No.
To take steps under the provisions of the
If they
2013 Act.
choose.
Yes.
Appeal dismissed. It will be naturally open for the state or for the acquiring authority to take step under the provision of right to fair compensation 23.
Because they can,
Yes.
they can acquire at any
Yes.
point of time.
Yes. This is the order of the Supreme Court. Then when I moved before the single bench. Then the next order, Eastern Coalfield Limited, same thing. A direct 2 months time is given to hand over position and compensation. Against that, they moved the division bench. Division bench, same order.
No, Mr.
Now, question
Shah,
is,
when?
I'm telling. Now I'm making facts. I have told you lordship in short. Same order by all the courts. Now, what is the position? He has to return me the position and give me compensation, rental compensation for the portion of period occupied by them. Well, when they will give me the position, this is number one date. And if he do not give the position, then he has to follow the Supreme Court decision under 13 Act. He has to give me compensation. Let them ascertain whether they will be able to give me position of the land.
Mr. Saha, why did you file a separate writ petition instead of filing a contempt for violation of the order dated 17th of October 2012? It was the division bench order. It was the division bench order affirmed by the Honorable Supreme Court. So not interfered with. So,
but a modification or a direction was given.
Modification.
In that sense.
So no, Mr. Shah, modification is if they choose to.
If they choose to.
If they choose to.
Yes.
But it has not been modified.
No.
It has not been. So order SLP was dismissed.
Yes.
So the order was not interfered with, giving them liberty to take further steps if they want. So they have not taken any further steps. So you want implementation of the order. Why have you filed another separate writ petition?
As they are not giving me position, nor giving me compensation, but I have filed a second writ petition.
What should be adjudicated in the writ petition?
Nothing.
So it's merely an execution of the earlier order.
This is an execution.
So division bench, then you again gone before the single bench, again before the division bench, again nobody knows.
Therefore, my humble prayer is let them decide whether they will be able to give me position of the land and when they will give me position. Let me ascertain that.
Mr. Dev, what do you say?
My lord, I pray for money to the ECL, but they did not refuse to do so up till now. I have nothing to say, my lord. ECL, my lord, Amit Pan is there, my lord. I told him, give me money, I will give the money and he will give the position to the, according to the to comply. Amit Pan said, my lord, that I took all the assistance of the ECL, so I must.
How you are appearing for whom? You are for the petitioner.
Petitioner.
Mr. Sen, you are for the.
Number 7,
what is your stand?
But my stand is covered by the judgment passed by the Justice Court.
Compensation will be divided between us.
Oh, so you also stand on the same footing. You are supporting Mr. Shah.
Compensation will be divided amongst us.
That has been observed.
Then Lordship, keep this matter on Thursday.
Thursday, Mr. Pan will be able to come. Please take instructions. He has undergone a surgery.
My lord, his clerk said, my lord, he will come on Thursday.
He will come on Thursday.
Yesterday, my lord, he
On time, my lord, I have not objected anything. Let them take instruction. Let them come.
Keeping it on 19th.
Yes,
Let him because heard Mr. Shah.
আসতে বলো অনুষ্ঠানকে।
Yes.
Okay, my mapping from the state.
Petitioner, my lord.
State respondent.
Yes.
My lord, the private petitioners are the owner of the land. My lord,
Not
private respondent, my lord, are trying to snatch the land,
Snatch the land.
trying to digging the and
Presidentji, what have you started
trying to
doing?
making it water pure
Just snatching away the lands.
and to making the water body. Therefore, my lord, petitioner made representation before the DLRO and also
Agricultural land to a water body.
also the
Yes, what is your instruction, sir?
I am submitting the inspection. My instruction.
Regard to the change of the nature of the cat, when it is come under 4C of the WBLR Act.
Lordship, I mean,
I'll come to page 34, my lord, representation to the district magistrate.
You will be happy with the direction for consideration.
Thereafter, my lord, district magistrate, my lord, come to thereafter, my lord, come to page
Yes,
38.
let me see. Yes, sir, what is your instruction?
my instruction is that the state respondent authorities have taken the steps according to the law. First of all,
What
I am
steps have you
placing
taken?
a police report. I am submitting the police report.
Police is neither here nor there. Where is the BLRO report?
BLR report I am submitting.
Please submit that. Police report is neither here nor there. Yes.
Astam journey is
Yes, what steps have you taken?
steps.
Yes.
We have taken the steps.
What steps?
Field report is there.
Field report is neither here nor there.
And subsequently status report has been given.
That's all. What
That's
you
all.
could do. Should not remain in that post then.
According to the.
You should not remain in that post then. You are not fit to remain in that post. If field inquiry and status report, filing status report before the court is sufficient compliance, you are not a fit person to hold that post.
their submission is this, the writ petition is based on the presumptions. About the
on
presumptions, yes.
Have you gone
They
through
are
the
trying
report?
to, they are trying to.
Have you gone through the report? You have a copy of the report, place from which portion states that it's based on presumptions. Your instruction is otherwise.
Lordship, have a look at the last page.
No, I'm on the first page. The second paragraph of the first page. Please read it loudly so that Mr. Bhattacharya also can hear this.
No, my standard was I am not related
No.
to that.
I'm saying that you can hear this. Maybe in your favor. You do not have a copy of the report. It might be in your favor, so that I've asked him.
I am served with the report, my lord. There is a
Yes, please read it loudly. Second paragraph.
In pursuance of the said reference, a field inquiry is conducted on 13/6/2025 at about 11 a.m. by the concerned revenue inspector. At the time of inquiry, some of the complainants as well as the local villagers, riots were present, and the
second paragraph in the field. Yes. Second, next paragraph, please place. First page. Why are you going to the second page?
Oh. In the field, it is seen that some riots of Maushali jail number 127 have been excavating earth by JCB for forming a new jail. The position is the subject jail is southern part of the Mauja. It is seen that the two old jails are situated just beside the subject jail. One, Apurva Jana, son of Megnath, is the
Apurva
owner.
Jana is Mr. Bhattacharya's client.
We are not.
He is not your client.
Yes, my lord. That is also my lord.
Yes. That is what I am saying. It's
Yes,
your client.
Tushar Jana and Apurva Jana.
Apurva Jana, yes.
It is the claim of the petitioner.
No.
Yes. Kindly see that.
Yes. All right. Yes.
Then petitioner claimed that Apurva Jana is excavating the earth for the new jail, but the Apurva Jana present at the time of inquiry said he is not excavating the earth for new jail, and they also said that those riots who are willing to form a new jail, they are excavating the earth.
So excavation has been found. What steps have you taken for that?
Not in the plot of petitioner's portion.
No. In the
petitioner portion.
Position.
Not found in the petitioner position.
In which plot this excavation was done? Have you mentioned that? In which plot?
Lordship, kindly have a look at the police report.
Police report is neither here nor there. Revenue inspector is the authority who has to take steps. What will the police do? That is why I told you he is not a fit person to hold the post.
Next para I am reading out.
Yes.
It is also known that this proposed jail will form except the lands of those riots who are not willing to give their land for proposed jail. It is pertinent to mention here that the earth
So
excavation.
if the riots give their land for construction of a jail, that will be done. You will allow that. You will allow that. Being an authority under the Land Reforms Act.
What is happening in this matter?
Mr. Bhattacharya, I will call upon. I know your anxiety.
No, I am not related to that matter.
Yes.
I am not the owner.
Then you do not have any anxiety. Yes. Ashun.
The land was for the cultivation. It is not for you lost it. Make an inquiry. This land is unfit for the cultivation. Absolutely.
The petition. Yes. Yes.
22. I'm 23. I'm filing my affidavit.
Mr. Pan, where is he?
He has some difficulty, but he will have to undergo eye surgery after he's paying for 26th. Affidavit will be filed in 23. My lord.
You already served the
Affidavit?
Opposition.
You already
Have you filed affidavit of opposition?
Today I'm filing.
All right, affidavit.
Then whether the gift to a minor,
By the natural guardian.
maybe, but
Please consider this, take a decision.
And one
One
thing,
presentation, please take a decision on that. The petitioner, uh,
At 25, I am appearing on behalf of the petitioner.
Yes.
This matter is also for the non-payment of amount due to the on the last occasion, your lordship directed the respondent CMO to file a report. They have filed a report. I have also received a copy of the report.
Yes, what does it say?
Saying that the
Where
father
is
of
the report?
Lordship, may I hand over the?
But I want to file an exception to such report.
Yes. Mr. Dhar, what do you say?
Kindly see the
What is the basis of that construction?
gift.
Where is the deed of gift?
Local Gram Panchayat is the necessary party. After seeing this, kindly
No,
come.
that's a different thing altogether, but you are the CMH.
Yes, well, kindly,
you are
kindly.
the sanctioning
1,
authority.
2, 3, 4, 5th paragraph.
Yes.
Kindly come. It revealed from the locals that father of the petitioner, Mr. Such and Such, took initiative around 2005 to donate the land for the purpose of construction of the subcenter in the area. And construction was done by local Gram Panchayat upon funding from Health and Family Welfare Department. Then the building was made at an allocated cost of rupees 8.5 lakh at that time, which was allocated to Gram Panchayat for construction from time to time. We only disburse the fund. Then,
What is
Malon,
the basis, Mr. Dhar, of disbursing a fund? You disburse the fund when it is paid for. One will
yes,
say, yes, we will construct.
No,
such
for
and
all those papers, I need to find out from the Panchayat authority. This is a case of 2005. Now he is coming in 2026.
It happens, Mr. Dhar, when you will appear on that side in a acquisition proceedings, challenging an acquisition of 1976-77.
This is a continuous acquisition is something else. And well, here
this is possessing without any authority unless you can show the gift deed. Mr. Dhar,
for that,
how are you sanctioning funds?
No, let one Panchayat come before my lord. The authority is the even sanctioning authority is the Panchayat. Fund definitely by us.
Yes. So, please show me the basis of release of funds, on what documents. you have released.
Those documents I'll have to.
The Dhar, it's not so easy
all documents.
that you are releasing funds,
Manoj, kindly
without
come.
vouching the documents.
Manoj, kindly come to
Sanctioned order and
the
all annexures. We also first annexure 1 thing.
and kindly come to annexure after the photograph. Page marking to name. করবেও না তোমাকে বলেও ছিল। Manoj, kindly come to annexure 1.
Annexure 1.
Yes. After photographs.
Yes.
This is the transferring the fund. On what basis? Well, that basis I have not annexed in this, because those are documents. If my lord wants, then next page, my lord, kindly come to particulars. Then for the ground floor cost and first floor cost, then my lord, kindly come to the sanction plan. Then my lord, kindly come to
It's in the year 2006.
construction of GP headquarter SC, another sanction plan.
2008.
Then annexure 2, this is an estimate of 2008.
Mr. Dhar, please see whether there is any document to show that it was gifted.
Yes, and I'll have to পঞ্চায়েত বলতে পারবে, তুমি বলতে।
Paragraph 5, they have stated that my father has took initiative in the year 2005, whereas the fact my father has died in the 1970, and I have the record of rights in 1997, which showing that the plot is in my name. Kindly see, my father had died in 1st of January 1970.
Mr. Dhar.
Kindly see.
No, I don't know.
That is why, my lord, I am seeking
Very serious then.
The permission to file exception, my lord. And this is the record.
Whatever would be
of
the
97.
consequences.
My lord, kindly see the record of 97, which reflects my name. Right hand side, my lord.
ওটা কি দিলে আমাকে, দাও একটা কপি।
What is your name?
Ablun Bibi, my lord.
Abdul?
Ablun Bibi.
In respect of this plot, what is the plot number?
My lord, plot number is plot number 2272.
2272?
Yes, my lord. That is appearing last plot. My lord has found, my lord, last plot number is 2272.
Yes, in 2005, he was not even the recorded owner.
And he had died at that point of time, my lord.
No, I've got no. Well, kindly come to their writ petition. It's paragraph 3 is 2272, and my lord,
2272, it's recorded in
yes,
the
yes,
petitioner.
yes.
So if that is so,
And that is the ROR is at page 20.
20.
Yes, yes. ROR is at page 20, and my lord will find Oblun Bibi, his name is up there, and 2272 is Aman, Sreni Bhukto is Aman. My lord has got it.
Yes, yes.
Yes. And my lord, in their representation is also at page 23, annexure P3, 22. Are Baba, আমি তোমার সাপোর্টে বলছি 2272.
It's also not been recorded in the name of the Shastro, that center. It is the difficulty of the report. That is why I direct filing of the report in the form of an affidavit. No one is taking responsibility. Ashun. The report
to supply these documents through exception, or I'll hand over this.
Let them come up,
My lord.
then exceptions.
My lord, my lord.
My lord, I'll have to see the copies. My lord,
Copy.
my lord, the copy which has been handed over by
Please
my
give a photocopy to
My
him.
lord, my lord, I'll. Grateful.
Yes.
Item number 130 to 132.
My lord, in item number 130 and 131, my lord, and I have an application of intervention, my lord.
Yes.
My lord, in WPA 1013, I have can 2, my lord.
Yes.
Lordship, I am a member, my lord, and besides that, my lord, I am also a candidate in this ongoing election, my lord. And my lord, any result that may come out of this election will have a direct and substantial bearing on me.
Yes.
But I am for the petition. But I am for the petition. But I am for the petition. So far the cans are considered concerned. We are not opposing. Let them be added as party.
Yes. Yes.
In 130.
Then, my lord, in that case, my lord, kindly allow me a writ of writ petition be served, my lord, so that Lordship has already passed an order, my lord. My lord, kindly see, my lord, the order. A similarly placed circumstances, my lord, has already passed an order. My lord, kindly direct them to supply a copy of the writ, so my lord, that we can file an affidavit in opposition, my lord. Lordship, I have placed that order, my lord. I'm sorry, somewhere marked, my lord. In the similarly placed person, similarly placed situation, my lord, Lordship has already passed an order. Obviously, directing them to be implemented as a party and also giving a right to file affidavit in opposition.
On record and namta ki
Hey, mate, naam ki?
You are similarly placed with the other respondents.
Namta bolo to.
My lord, copy has been served upon the advocate on record through email.
Oh, well, Lordship, allow me, I will file an affidavit in opposition.
Yes.
Like
Yes.
My lord, in item 131, my lord, I am for the petitioner, my lord. May I be allowed to file the affidavit in reply to the 2 CAN applications? Affidavit in reply in connection with the main writ petition and 1 affidavit in opposition to the application for addition of party.
WP 4549 bolche.
131.
And I have can 3, my lord, the same prayer in 131.
I find, my lord, I'm appearing for the added respondents in WPA number 4549 of 2022.
That is 131.
My only submission before your lordship, in point of time, this was earlier filed. In point of time, the latest one up to 2005. So, my lord, kindly take up this matter and I have a point in regard to that mentability point.
You want which matter to be taken up first?
4549.
4549.
Your point of time, this was the earlier.
Yes. What is the issue in that?
Now, my lord,
In 4549, I am for the petitioner, my lord.
but I'm taking a mentability point, and I'm trying before your lordship that this has become completely infractuous and ineffective. I take your lordship, my lord, to the prayer portion of this writ petition.
Yes. 4549
But before taking up this matters,
4549 is petition. Copy serve করেছো তোমার 4549 বলবে তো তুমি
Your lordship.
Yes, my lord, already my have given the order sheet.
for election commission 1013. We are filing our lord affidavit in opposition. And the copy.
We have prepared the reply also.
And there the mental point we have taken. And that I am relying upon in other 2 matters also.
Yes.
But so far as the other factual aspects are concerned, we will to reserve our right subject to my lord's approval to file affidavit in opposition if required. Yes. So, my lord, I am filing this, my lord.
And there my lord has also kept the maintainability point open. So my lord, here also my lord kindly.
1013.
So that you can deal in affidavit.
Your lordships.
File your affidavits. Yes.
Your lordship, on the last occasion, the matter
Kindly give me the direction, my lord.
matter was kept on 9th. And they were directed to give us an advance copy of the reply within 2 days. We had given our opposition on time, but we have just received their reply 10-15 minutes ago, your lordship. We have to consider it and then come back, your lordship. This single person at the vague end, at the time when the elections is scheduled to be held tomorrow, without making others a party, has come up with such grave urgency, is not complying with your lordship direction to supply the copy of his reply on time, has given us a reply
We
today.
have been trying since Friday.
Today,
Landed advocate was not.
May I suggest one thing?
Opportunity we have given.
If
We
they,
have given.
if they say
At their fancy it cannot be
we
given.
have got the reply
If he
15-20 minutes ago, your lordship.
Even Mr.
Let us-
Karmakar has come back and copy 5 minutes ago.
Yes, Mr. Sarnan. Yes.
What is now I take your losses, my lord. 4549, I'm taking a mentability point right now.
Yes.
If you look this, I will. There are 2 annexures only, 2 pages.
Yes.
Kindly come to page 14 first.
Page 14 of the
Of the writ petition.
ভাই 4549 এর কপি দাও।
এই জাজমেন্টের কপি এসছে তো
4549
এই নাও
রিট
তো।
পিটিশন
জাজমেন্টের কপি
টেম অ্যাডভোকেট অন রেকর্ড
জাজমেন্টের কপি
জাজমেন্টের জাজমেন্ট গুলো
now your losses kindly see this is a letter dated
14 of the writ petition.
4549
Of 20.
I am here to receive a copy, my lord.
14, yes.
Page 14 annexure P1 letter dated 24 December 2021.
Yes.
This is a letter of prior intimation on behalf of our cooperative credit society regarding election of members of board of directors falling due on 29th March 2022. Since last board was reconstituted on 29th March 2017. Well, these two dates are right. On board meeting under jurisdiction of assistant returning officer for your consideration. We are running our cooperative credit society at a huge volume, which will find from your audited statement of accounts of the year under recent audit along with the audit report of senior grade 1 Tomlo. That is to say, we have members deposit of rupees 80 crore as on 31st March 2021 with an annual turnover of rupees 25 crore in credit service business, annual turnover of rupees 21 crore in servo business. We, the members of the board of directors at present, are seriously worried about the time gap between the date when this board will be dissolved and the date of the new board will come to function. Our business will face a huge difficulties for the days during the time of board remain defunct, and the society may suffer a huge loss for the same, which may ultimate hits for sake of members in the society. Now, my lord, kindly see the next letter, page 15. This is, my lord, your losses will find of 7th January 2022. In pursuance of the notification dated such and such, respectively of the Cooperative Election Commission, I do hereby appoint allot duties of the assistant returning officer to such and such of inspector of society, Holdia development, holding election of Holdia IOC, all that towards constitution of delegates and the board of directors, including election of office bearers in the manner provided under the act and the rules. Well, this much is relevant. Now, these are two letters, your lordships, when this, my lord, board was alive. Board was alive. Because they have on their own sense, 29th March, the board will come to a defunct board.
29th of
March
March
2022.
This was filed when?
Exactly, I take your lordships.
10th of March.
10th of March. Now, with the prayer, your lordships can have a look at that. Prayer, your lordships will find page.
So they want election.
I take you.
How election is being done?
Your lordship.
Do two prayers.
He's taking the point of maintainability.
Kindly.
He has the first right of audience.
Kindly have a look at page 10, prayer B.
Prayer B.
To convene the election of board of directors of the society with immediate effect, so that the members of the society can exercise their democratic rights in election of board of directors. One, kindly, see your lordships. C, to take all steps for election initiating process. Kindly F, to pass an interim order restraining the respondent authority to appoint any administrator or special officer for the constitution of the board till disposal. I believe there is no interim order. Now the special officer has been appointed.
They want election. Elections is being held.
That's what I'm saying.
So I'm recording that the elections is being held. This has become infructuous.
That's your lordship.
I'm allowing their writ petition. I'm allowing.
That's your lordship. But no,
no.
What they have done, your lordships, they have taken out one application and supplementary evidence. Kindly have a look at this. That's what I'm taking. That much, my lord, I am accepting.
Yes.
My lord, your lordships will find one app can two.
যদি এটা আমাদেরকে কপি দেয় আমরা কালেক্ট করেছি
Can two. But we have not been served any copy, but we have got it. Can two, my lord, in connection with 4549.
Where is can two? দেখুন তো can two কোথায়?
No, first 5.
4549.
4549. তুই তোর নিজেরও বই আনিস না
বই এনেছি
তো তো আমদি
Let me come back one by one. Three matters, so many applications, so many affidavits.
No, I think your lordship had noticed the amount. Your lordship had noticed the amount.
I will not be able to sleep then, Mr. So I do not look at the amounts. অন্য ফাইলে এটা 4549 তো হ্যাঁ yes yes
I will straight away take your losses to the prayer. And page 9. An order be passed thereby declaring that the impugned final voter list published by the ARO on such an is liable to be quashed. Second, an order be passed directing the respondents not to proceed any further on the basis of the final voter list. 3. An order be passed declaring that the publication of the final voter list and the notification of such and such are illegal and not in consonance with the provisions of the statute. D. An order be passed saying the publication of the operation of the final voter list and notification issued by declaring the election program. Now, my humble submission is very simple. Can this way the scope of the writ petition be enlarged and distinct phase cause of action can be brought to your lordship notice for consideration? By way of application, no one can ask for certiorari. No one can ask for mandamus. There is no other appropriate application except this. And another, I find your lordships, supplementary affidavit. Same facts have been introduced. Probably he has been advised by supplementary affidavit, you cannot do, file an application. Whatever the principles of law applicable in supplementary affidavit in the facts of this case, in the scope, considering the scope of the writ petition, that will be similarly applicable to the miscellaneous application. One cannot extend the scope of the writ petition. If at all aggrieved, he could have filed a fresh writ petition. I am showing one judgment to your lordships.
এটা পরবর্তীকালে অন্য জজমেন্টে রেফার হয়েছে সেগুলো হয়েছে
কত প্যারাগ্রাফে দেখেছিলি জাস্ট আই গিভিং ইউ লর্ডশিপস that by way of supplementary affidavit, no one, I take your lordship paragraph. Your lordships will also find a supplementary affidavit. Kindly take up first your lordship that also.
In similar lines.
And then kindly have a look at this.
Supplementary affidavit.
It has been affirmed on 27th of January 2026. Supplementary affidavit by the petitioners. দেখুন তো নিচে আছে কি
দেখুন তো কোথায় আছে
নিচে দেখুন
আবার কোথায় আবার কোথায় supplementary affidavit to the affidavit in opposition? No.
to the affidavit in opposition filed by the petitioners.
Supplementary, this is that.
Supplementary affidavit to the affidavit in opposition filed by the petition.
Against can 1 of 2022.
Can 1 of it. That can has been disposed of by your lordships by adding them the part.
The can was disposed of on 27th January.
So, your losses, I'm not taking your losses to that.
Right, what is the supplementary affidavit?
Supplementary affidavit, he is disclosing the affidavit, some resolutions of the board of directors, the then board of directors. Then your lordships, when the present added respondents have been formally declared to be the members, that declaration of that final voter list, all that your lordships. On the similar line, your lordships.
I think those are being challenged in the other writ petition.
That's your lordship, sir, Mr. Mittu will deal with that. Because I take your lordship that when they have found that this writ petition they cannot continue with, they have projected someone. I'm not making that assumption because I'm appearing in this one. Your lordships kindly consider this judgment, paragraph
6 and 7.
This is reported in 2009, volume 2 CHN, paragraph 6 and 7. Paragraph 6 and 7. 2009, volume 2 CHN, page 947.
Paragraph
6 and 7.
7 to more relevant.
The petitioners possessing Lady Brabham needlework diploma. Has you also got that one?
I'm coming.
Relevant page 953.
Yes.
In
Yes.
writ petition number such and such, the petitioners possessing Lady Brabham needlework diploma have prayed for a direction upon the respondents to treat them eligible for the post of assistant teacher in work education, to allow them to appear in the selection test and thereafter to consider them for their empanelment. As noted in writ petition number such and such, prayer has been made by filing an affidavit for quashing the rules and notification regarding advertisement. In my view, challenging to the rules of 2007 on the basis of the grounds in the supplementary affidavit is not tenable. Challenge, if at all, should have been by way of an amendment of the
Sir,
writ
Shanal,
petition.
there is a distinction. Challenging the rules, it has to be a substantive challenge. But in cases where there are subsequent events,
Subsequent, Malad, I tell you,
challenge,
Lordship,
this is something has some distinction.
I tell you, Lordship,
Because challenging a rules cannot be by way of a
Malad,
supplementary.
challenging, praying for any quashing certiorari or mandamus cannot be done by of an application.
That is what this decision says with regard
By
to
way of supplementary affidavit cannot be done.
challenging a rules. Rules.
No, that's fact. You
Stands
know,
on a
kindly come
different
to
footing altogether.
Malad, paragraph 7.
Yes.
It appears in Bharat Bhari Udyog Nigam Limited Supra that the practice of bringing on record the subsequent events by filing supplementary affidavit after filing of the writ petition, which was allowed by the learned single judge, and thus bringing out a new case, was disapproved by the division bench.
It's a well settled proposition, but Mr. Shanal, at times you are coming up
No.
saying, look, subsequent event, if I file an application for amendment, then objection, then it will be, if it is allowed, then a
No,
fresh petition amending
I deal with
will
this.
delay. That is why
That
it
I
is
deal with these views of your lordships. Now kindly consider the prayer. Election. Election has been initiated, process. Prayer for interim order, don't appoint any special officer. Special officer has been appointed for long back as on 2022 April. Now, my lord, is it the subsequent facts which they have brought on by are related to this issue?
Yes, that's
why, my lord, it cannot be. So they cannot do that by way of that.
submission,
That's why I'm citing this judgment. Paragraph 7. Then your lordship see, the law is it should be done by amending the writ petition. Therefore, challenge, my lord, that's present fact.
I'm not disputing that it should be by way of an amendment. It's no dispute.
Even, my lord, I take your lordship,
Because there is
probably
no practice of filing the supplementary affidavit. This now once you want to amend some averments, something cannot be by way of a supplementary affidavit.
My lord, I tell you, lordship, kindly, your lordship, probably your lordship also do not allow this. When your lordships allow the subsequent, my lord, pleadings, suppose I have prayed for appointments. In doing with appointments, your lordships in between, after filing my affidavit petition, some cases have been given effect to. I can
bring on record certain subsequent facts
in relation to my main prayer.
Yes, but
this is not that.
If you want an additional prayer, additional relief,
face cause.
Yes, other grounds, it has to be by way of an application. I'm not for a
kindly see,
not for a moment, Mr. Shanal, disputing this proposition, your submission of yours.
That's your.
But the question is, at times you are coming up and saying, no, please allow me to file up. I'm not saying you. I'm not pointing out to you. But I'm saying that
I take you only
these prayers are being made, saying that it will delay if I file an application for amendment.
No, Malad, this is a completely fresh cause of action. They are disputing the entire final voter list.
Remember this, Mr. Shanal. I will apply this in all future cases.
Malad, in appropriate case, but your lordship,
inappropriate cases.
This is not
in
your lordship. In
cases,
case of
no supplementary affidavit, all applications.
Now, your lordships kindly remember that, my lord, that here, my lord, even the writ petition though was disposed of, the Supreme Court judgment, that by way of miscellaneous application, you cannot bring something.
87.
That's
this is their doing, your lordship.
Well settled, because
87. Supreme.
This supplementary affidavit, if you go strictly in the civil procedure code, there is no concept of that. If you want to amend anything, even a prayer, even a typographical error, anything, you have to do by way of an amendment application.
Malad, may I?
But here you may say, no, that principles may not strictly apply, procedures will apply, shortcut method. This is
But
being
I am
applied.
proceeding little further. I have placed the facts which are necessary. Malad, considering the scope and scope
Yes.
of the writ petition, even
Whether
the amendment
this should be
application
allowed
cannot
or
be allowed.
yes, yes. That I
That's the point. Even the amendment application cannot be allowed. It's an
that I will
entirely
consider, and I'm telling you, I am not disputing this proposition. It's well settled
the
proposition.
other thing.
But you are not allowing me to follow this proposition at times.
Malad, I think Malad, all are subsequent events that's related to. Malad, had it been a case that the election process has been questioned.
You do not know supplementary affidavit, additional grounds, additional reliefs, additional pleadings.
Malad, this is adversarial proceedings. Your losses, if someone takes the point, your losses consider that. Sometimes Malad, the respondents do not take. Situations are there. If they take it, the Pandorum box will open. There are cases, Malad. So they don't take that point. They accept the stand of filing supplementary evidence. So Malad, that's different issue. Now this is the one point, your losses. I will take your losses, the two judgment that Malad, kindly consider this. This is Malad 71 CWN.
On what each point?
Point that during the pendency of the writ petition.
Please, 71 CWN page?
71 CWN page 396.
396 on what issue?
Issue, if during the pendency of the writ petition, your lordships, if the body comes to ends the time framed by the statute, they cannot proceed further with the writ petition. There are two judgments, my lord. One of Justice D.K. Basu, and another judgment, your lordships, of Justice Chittatosh Mukherjee. Both in respect of, on the similar point, management committee of an aided school can function after spent its life. In both the judgment says, even the writ petition pending, if the managing committee's terms, statutory terms, spent its force, then they cannot proceed with the writ petition. That's your losses. Here your losses.
Photocopy of that.
That's
condition of the book is not very good. As I can see.
Old book I purchased your losses. CW and I didn't have. Now I take your losses paragraph.
Hand over it to me because we have a photocopy of that.
May I hand up this?
Because by using this will get further damage. That's it.
Blood, he started argument, blood.
He's raising the point of maintainability.
Right.
Your matter.
Blood, so blood. Yes, blood, I understand. But I can just to refresh your lordship's memory, blood. To refresh your lordship's memory, blood, I must submit, blood, on the very first day. But may I submit?
Paragraph?
I give you losses. Paragraph 35. SEC online. Paragraph not only have the petitioners.
It is to be noted.
No, my lord. Not only have the not only have the petitioners failed to establish, this starts this language. আমাদের লাইব্রেরিতে নিয়ে আনলি না কেন?
Shanal, I have got one thing. It remains to deal with the plea of Malafides. Point number 4. Is it anywhere nearing that?
Paragraph. I just. There for 4 reasons are given in the impugned order. Have you losses got that? Probably paragraph. Not only have the petitioners.
I therefore agree with Mr. Chaudhary appearing on behalf of the respondents. There was sufficient compliance with the conditions of section 28(2). It's not telling.
Now it remains to deal with the plea of Malafides, your losses got.
Malafides
plea of Roman 4.
Yes, Roman 4 I got that. I think
that's paragraph 33.
Paragraph 40, I think.
That's then your losses.
It remains to deal with the plea of Malafides, that is paragraph 41.
41. Then I think 43 would be probably your lordships.
In
not
fact,
only
the
have the
impugned order is a speaking order.
No, not only have the petitioners failed.
48.
48. 48.
Paragraph 48.
Exactly. 35, 48.
Not only have the petitioners, yes.
Not only have the petitioners failed to establish any of the points urged on their behalf. they are not entitled to any relief in a proceeding under Article 226 for a paramount reason. The term of a managing committee under the rules in force is 3 years from the date they take charge of the school. These date being the 2nd February 1964, according to paragraph 5 of the petition, the statutory term of the petitioners committee, irrespective of any other consideration, has already expired during the pendency of these proceedings. The petitioners have therefore no substantive right to membership of the committee, and the court cannot hold out an infructuous relief in the instant proceedings. Lord, kindly see the cause title of the petition. Society is the petitioner number 1, and the petitioner number 2 is the ex-secretary. So how can he maintain the petition? Neither the body nor the petitioners.
Yes.
Well, this is, I
Can you
think,
give a copy of this?
yes, yes, certainly I will.
Yes.
আরেকটা
Yes, সেটা দিয়ে দিন।
Page কত? Just a minute, another one. আনবি না কিছু? Well, another, I think, 70.
Before he cites other judgments, lad. Only one minute from my second. Lad, the very first day, lad, I made submission that the other writ petitions, which the state respondent expressed the desire to tag with my matter, has nothing to do, as in fact has become infructuous.
Which matters
The,
are become
the matter which is being argued by Mr. Shanal.
that has
So
become
far,
infructuous.
Let the petition.
so far my understanding, lad, so therefore, lad, my writ petition.
That is also the submission of Mr.
No,
Sharma.
no, lad, that is, I am not defending that. So far, my writ petition is concerned, lad, that should be here out separate. That is the reason that the matter was taken up. Because due to urgency, I mentioned this matter before election, and you should heard this matter before election.
I have also fixed it just one day.
Yes, that's lad. Unless that my matter is taken up and decided.
Ahmed, what can be done? You are not present there. Mr. Sharma said it will be had
Lad,
to be
my
taken up in order of precedence.
Lad,
Filing of
my junior was there. Since he was his designated senior, you could not oppose. To be very, I asked him.
No, my learned friends, I do not find, sir.
Lad,
Insisted the writ petition on the last occasion.
No.
They also, he was of the view that
Not by us.
reasonable.
Not by us. Not by us.
How can you do that?
Lad, in my matter, lad, kindly hear my matter first, because that is the matter connected to the election.
I will hear you, Mr.
Yes.
Ahmed. I'm not saying I will hear. Not hear.
I'm sorry.
I am, my lord, in the application.
Mr. Ahmed's matter.
Mr. Ahmed's matter, I am taking a preliminary point.
Mr. Shanal, how long you will take?
But that this I will because
Cite the
if you-
decision, only one
Amendment
minute, I
will
think
be
you will
fine.
be citing the decision. You are not concerned.
I'm
with
always
that
in
matter.
apprehension.
I will hear you, Mr. Ahmed. Yes.
now your losses will find, this is 1972 CLJ,
Yes.
page 148. Paragraph I give you losses. It's a very
For what proposition?
I just read out your losses. The term of the managing committee of the school having expired in 1964, that is on the expiry of 3 years from the date of its reconstitution. The said committee was not entitled to function as such. Any act purported to be done by such managing committee is ineffectual and void. This is the problem. I will give the photocopy also.
Give the photocopies, please mark the paragraphs.
Yes,
because,
I'll do that, your lordship.
the paragraph.
This is the
paragraph.
Paragraph, your lordships, 5 and 6.
All right.
It's stating the facts. I will give the number also. May I hand up to your lordship because
Don't give the copy, please give the photocopies.
all. Well, this is in regard to maintainability. If your
Small
lordship
submission of,
holds against me, then I will go on.
a one-liner submission from the part of the special officer, Your Lordship, because now I am in charge of the cooperative society. Kindly seize the affidavit portion of the can 1.
Can 1.
This is can 2. Can 2, by way of which they have brought in certain facts
Yes.
and asked for additional prayers. Your Lordship, kindly seize.
Yes.
I, Dipendu Das,
Yes.
son of so and so, that I am petitioner number 2 and duly authorized by the society. The amount of
authorized by the society now.
the amount of fraud, and kindly seize the supplementary affidavit. It also says, starts with the same thing. Client
All right, followed. Yes.
and I am the petitioner number 2. I am duly authorized by the society. This is a fraudulent submission on oath.
All right. Yes, which is your matter?
May I
Mr.
start
Ahmed?
from him?
Submissions with regard to 4549 on behalf of the petitioner.
Your main prayer is now, if I can allow you without the supplementary and the can. If you want, I can allow this, your prayer to hold elections which is being held. I can dispose of with that. Now, if you want the supplementary reliefs and the other reliefs, then
I'm not pressing the can, not pressing the supplementary either.
so what do you want now?
My two submissions are, my lord, subject to my learned senior friend's submissions. I am addressing the second aspect first. That is the petition number 1, which was the cooperative society has now, the board is no longer there. I am not representing the petitioner number 1. The petitioner number 2 to 5 were individual petitioners. Petitioner number 5 is no longer in this IOCL Haldia refinery that I have placed on record by way of my today's affidavits. Now I am representing the petitioner number 2 to 4. Though they were individual members of the society. As individual members of the society, in my respectful submission, they can have carriage of proceedings with regard to the writ petition. So far as the first aspect is concerned, whether the writ petition has become infructuous, in simplicity, the prayer of the writ petition was for ensuring holding election in the society so that there should not be any hiatus in the democratic management of the society. That it, and
I'm allowing your prayer.
and the election is being held. Now, my lord, here one aspect is when we moved the writ petition, when we filed the writ petition on 10th March 2022, we made prayer on the basis of the actual situation which was then prevailing. Our prayer was that the election was to be held in accordance with law.
Now it is not being held in accordance with law. According to you.
This is my submission.
Wait, all of you are challenging
Only
the voters'
my lord, only may I add only one sentence. Maybe I'll tell only one sentence. That is why it is not being held in accordance with law. In my respectful submission, the law, as has been laid down by the Honorable Apex Court in judgment of T.A. Kuttappan, says that the election shall have to be held on the basis of membership list that was there during the completion of the tenure of the last elected management. Now, here the board of the list of members got changed subsequently during the pendency of the writ petition. My only prayer is to hold election on the basis of the list of members that was recognized in the audit report by the Directorate of Cooperative Audit, which was then at the time of filing of the writ petition. On that basis, the election must be held. That is my only submission with regard to the writ petition.
Yes.
These submissions are not in the writ petition. And the petition has been affirmed that the petitioners are office bearers.
That point of
Mr. Mitro was
members are not
Yes,
changed.
Mr. Mitro, you want to raise the point of integrity first? Yes.
Secretary.
Mr. Shanlal, can you give space to Mr.
Yes, yes,
If
we are doing that.
File title din to. Mr. Ahmed, what is your writ petition?
1013.
101.
In this 1013, my lord, I am appearing for respondents numbers 7 to 26.
7 to added parties.
Added respondents as 7 to 26. My lord, here the prayer in the writ petitions are, my lord, regard to, my lord, the final voters list. Kindly see prayer B, C, etc. And this application, this writ petition has been made. Kindly note the date, 14th of January 2025 or 2026, sorry, 14 January 2026. Now, my submission is this, that once, my lord, the election procedure has started, then, my lord, the writ application is not maintainable. Already, my lord, I shall give your lordship a few of the dates from which perhaps your lordship will please find. My lord, on 3rd July 2024, sorry, on 27th August 2024, 392 members were inducted as new members in the society. That is their allegation.
Yes.
Our submission is this, that these persons were already members. It is only, they were only recognized by that particular order. Why is it so?
because, my lord, they were employees who had been inducted between 1996 and 2021 at different points of time. And on the strength of their becoming, my lord, employees of IOCL,
Automatically become members of that
automatically members cooperative society in terms of the cooperative, terms, my lord, of the bylaws. My lord, if your lordship wants to see the bylaw, my lord, I shall just place that particular provision of the bylaw. I don't know whether your lordship has got a copy. Lordship get a copy.
Bylaws has been annexed, I think. Mr. Ahmed, have we annexed the bylaws?
I do not think so.
Bylaws, I think,
Last
have
location
been
possible,
somewhere.
I have
Your
handed
lordship
over.
kindly sees
Last
them.
one I have handed over.
Well, your lordship has
To demonstrate
may
who
have-
are the nominal members and who are not.
Yes.
I think, yes.
Copy down.
অন্যটার মধ্যে ঢুকে গেছে কিনা
See, bylaw 5 and bylaw 6.
Yes, area of membership.
Yes, the area of membership of the society is limited to IOC Employees Welfare Cooperative and Haldia Division. And then 6, membership of the society is being individual, is being to, wrong English, to individuals above the age of 18 years of good character, competent to contract, residing in the registered area of membership in the permanent employment of IOC Haldia Division. So, my lord,
What are the preconditions for becoming a member?
yes, and my lord, a person, so my lord, one becomes entitled to become a member on being, my lord, the employees of IOCL. Now, these persons have given in their affidavit in opposition, my lord, your lordship will please to see, my lord, the dates of their appointment in the IOC, and also they have said that from month by month, from ever since their appointment, your lordship kindly takes, my lord, page 22.
Page 22.
Yes, page 22. Or one will do. Each of these employees, my lord, has annexed this. Kindly see, my lord, this chart, first, second, third column, and 8 entry, society membership.
Third column.
First, second, third column.
Yes.
From the left.
Society membership.
Society membership 100 rupees, and that is, my lord, your lordship will please to find in every page there is a society membership in respect of each of these employees. Society membership fees month by month has been deducted, and also not only that, my lord, kindly take also in this connection that another rule. Kindly come to rule 26.
Rule 26, yes.
Rule 26, this your lordship will please to find at page 9, I suppose.
The bylaws.
Yes.
Loans shall be granted to members only. So, my lord,
according to you, loans have been granted in your favor.
And this will be found from these charts. Kindly, my lord, take this, any of these charts.
Yes.
Loans have been granted and that is being adjusted. Page 22.
Page 22.
62 or
66.
Yes. Your lordship kindly comes to page 66.
Yes.
First, second, third column again.
Yes.
After, my lord, union membership, employee club, then society loan, 42,279. And similarly, 65.
Society loan.
Yes, society loan. Again, my lord, at page 65, your lordship sees. So, my lord, their contention is this, that they have already been inducted as member and they
are
were
entitled to the benefits as a member.
So, my lord, it is only what happened was this, my lord. Keeping this in mind, if your lordship looks into the date which has been given by the petitioner themselves, my lord, if your lordship will please to find, my lord, they have already been inducted as members, and on 27th August 2024, this date is important. This is, my lord, annexure P8 at page 83
of your application, of your affidavit in opposition.
of my affidavit in opposition. Kindly give me 1 second. Page, I shall just check up. No, it is not in my opposition. I think it is in the petition.
Writ petition.
Yes, in the writ petition itself. Page 83. Yes.
Yes.
These 392 persons were recognized by my lord the special officer.
In August, September 2022.
Yes, my lord, and kindly see date of joining. They are there. The last column.
Yes, date of joining is August, September 2024.
Yes, and my lord, they have been recognized as early as that. Now, therefore, my lord, they are not being inducted as members. The Supreme Court judgment that is being sought to be cited before lordship, there, the members, after, my lord, the election has been declared, certain members were sought to be inducted. Here, my lord, there is no question of induction of members. They are already members. They are being recognized only. This is in fairness of things. That was done. Now, but be that as it may, my submission is this, and this is the preliminary submission I am making before lordship, that once, my lord, the election procedure has started on 15 December 2025.
15 December 2025.
2025, Assistant Returning Officer published the draft voters list comprising of 732 persons, including these 392 persons.
Yes.
Once that has happened, my lord, my respectful submissions writ will not be maintainable.
Election process started.
Election process has started. So, my lord, what will happen is this: if there is any grievance of my learned friends that this
Election dispute,
they should
tribunal.
Tribunal. That is the preliminary point I'm taking on this issue, my lord. Aspect of the matter, my lord, I am only referring your lordship to, my lord, a few of the provisions of the act. Perhaps this will be of some importance of the cooperative society. Petition has been moved in the month of January 2026.
But he wants the elections to happen.
Yes, that is the problem. And my lord, for months, for years together, my lord,
He'll come up and say that I want in the prayer, please hold elections, but other grounds taken so as to stall elections.
to stall the election. And the result is this, my lord, since 2022, there is no elected board. My lord, the board which was elected, their office, my lord, they vacated their office. Special officer was appointed. Special officer did not hold the election. So, my lord, these persons
not or could not.
Could not, perhaps.
Could not.
Could not. Prayer long back in March 2022 for
That's right.
election in the society.
Exactly. This is exactly what I'm saying.
Members were added in 2024. See when the writ petition has come, only before the election. What you were saying, na, in 2026.
So, my lord,
They were in hibernation for all these years.
your lordship will please to, my lord, come to rule.
Or act.
No, act. First of all, act, and
Act
thereafter
দিলেন?
the act.
কেন ছিল তো?
আছে
Section
96. Cooperative Election Commission. The state government shall constitute a cooperative election commission, and so and so, and shall appoint a person to be the cooperative election commissioner of the election commission for the superintendent's direction and control of the election. These are superintendent's direction and control. The language of the Article 243 of the Constitution of India.
And this has been explained what it means by the expression
Exactly.
superintendent's
There are
direction. There are Supreme Court
Supreme
decisions.
Court judgment. My lord, in fact, my lord,
on that.
the famous judgment is that Tomar's judgment. That I have got that judgment for. Well, then it says the Cooperative Election Commission of the Election Commission shall hold office a term of 3 years. Then 4, the Election Commission shall hold election of all registered cooperative societies in West Bengal in due time under the provisions of chapter so and shall take all measures in this regard as it may think fit in such manner as may be prescribed. And then, my lord, subject to the provision, kindly see subsection 8. Subject to the provisions of this Act, the Cooperative Election Commission shall make rules, regulations, and procedure providing for the conduct of the election, preparation of the election electors.
96.8, what Mr. Ahmed was arguing on the last occasion, he was challenging the virus of that regulations by this.
Well, but this regulation is still there, and my lord, this is the preparation of the electoral roll for the election. Now,
because according to him, certain things do not fall within A to F, which has been provided in the regulations.
so that is perhaps with regard to the procedure, but that again, in my respectful submission, will have to be questioned before the Election Commission. If you want to challenge that, if you want to say that the preparation of the electoral roll of the election had not been properly done, then once the election procedure has started, then you should not. Well, in this connection also, kindly, my lord, come to section 63.
Yes.
Subject to the section 63, eligibility for membership of a cooperative society. Subject to the bylaws, the following persons shall be eligible for membership for cooperative society: an individual competent to contract under section 11 of the Indian Contract Act, and a permanent resident of India. Any other cooperative society, my lord, we come under A. So once that is so, we shall be eligible for membership. And then, my lord, and subsection 2, an employee of the cooperative society who is eligible under subsection 1 to be the member shall on an application made by him be admitted as a member of such cooperative society, but shall have no right to vote at an election of or for being elected as a director of the board of delegate to any other cooperative society. So, my lord, once an employee of the cooperative society or the cooperative of the cooperative society who is eligible, but so far as subsection 2 is concerned, I am not a member, I am not an employee of the cooperative society, because well, I'm
the employee of the parent company.
So, I come under subsection 1. Yes. Subsection
and
2.
The bylaws provide that automatically you will become.
Automatically I shall become. And my lord, the reason why I am pointing it out to your lordship, because
1 minute, Mr. Mitra, only one. Only one thing, Mr. Mitra, whether this membership is automatic or you have to apply.
Look, I have to apply. My lord, I'm grateful to your lordship for having pointed out. What I'm submitting to your lordship is once subsection 1 applies, then 2 and 3 will not apply. Subsection 3 is, my lord, with regard to the nominal membership. In fact, my lord, the nominal membership concept will not apply in my case. Kindly come to section 64. The position will be clear.
Yes, yes.
Section 63, subsection 1, read with section 64. Admission as member. Any person eligible for membership under subsection 1 of section 63 may apply to the cooperative society for admission as a member thereof in a form and the manner as prescribed. So, my lord, once I become an employee, I become entitled to become a member of the cooperative society.
You can apply for being
admitted. Can apply. And as and when I apply, if I comply with the provisions of section 63 1A, then, my lord, the cooperative society will have no alternative but to accept me as a member. And that's exactly what happened.
Yes.
That's exactly what happened in our case. 732 persons have been inducted as member. They applied for membership, and they had been, my lord, they had been held up. The entire thing had been held up since under the old regime of when the board of directors was there. They did not do anything. New special officer was appointed. He did not do anything. Now, my lord, the new special officer who is appointed, he is now moving in the matter in terms of the direction given by the secretary of the government of West Bengal, that do it as soon as you can. When he is doing it, my lord, a spanner in the works is being put by moving a writ petition and stalling the whole thing. My respectful submission is, once the admission of member is it is a matter of right. Section 63 1A I comply with. I apply under section 64. The cooperative society is bound to accept me. Unless, my lord, there is something. There has been no objection with regard to any of these persons. So, my lord, when, my lord, this application is made, the writ petition is made, that it has been wrongfully done, I said this is the only way it could have been done, and it has been done in that way. And that is why, my lord, if your lordship looks into the letters which have been written, my lord, kindly come to the affidavit in opposition, which your lordship has been looking into. This is the first letter at page 67, written to the Assistant Registrar of Cooperative Societies by, my lord, the Cooperative Societies Inspector. The inspector is writing to the Assistant Registrar Cooperative Society. If your lordship kindly comes to first, second, so and so, first, second, third, fourth paragraph. Each member of the said society, your lordship has contributes rupees 100 to TF. TF is thrift fund, which is deducted through their salary account, and this TF contribution is same for all members. The fee for membership are in the tune of rupees 10. That is not the same as TF contribution for each member. Then, my lord, the last AGM was organized on 15 June 2021, and the total number of so-and-so members who appeared to have in program in the quorum so-and-so. The last office bearer election was held in 17 March 2017. After observation of all requisites so-and-so, the board members is conspicuous. The board member, it is conspicuous to me that there is a division amongst ECS members and the society in the two ways, one share members and two nominal members. The society managed is given logic so-and-so, so-and-so. I take your lordship to the last paragraph. I mean to say, I have observed that the division among members, share members enjoy all types of facility, including voting right. The nominal member enjoy all types of facility except voting right. Whereas the area of membership as per bylaws of the said society is the permanent employee of IOC. This is what I said. A permanent employee of the society should be a member. I request you for taking appropriate steps so that all permanent employees, members, may get voting right in the next forthcoming election. This is, my lord, the inspector had written, my lord, to the assistant commissioner, assistant registrar, sometimes, my lord, in the year 2021. And kindly come to page 68. The government of West Bengal Cooperative Directorate, well, Assistant Registrar of Cooperative Societies, writing to the Secretary of Employees Welfare Cooperative Society. Dear sir, it is learned from the report submitted by the Inspector of Cooperative Society, so and so, that there are 449 shareholders members and 572 nominal members in your society, as stood in 6/12/2021. It also transpires that some permanent employees who are nominal members as well as are contributing regular deposit ₹100 per month. In terms of clause 5 of the registered bylaws of the society, every such permanent employees are eligible for shareholder membership. And in terms of Rule 107 of the West Bengal Cooperative Society, no person qualified to be a member of the cooperative society under the Act or the rules or the bylaws shall be excluded from membership. So, those persons, if applied for shareholding membership and found eligible, should be admitted. So, this is, my lord, a strong letter written in 2021. But the point is this, my lord, after they have been inducted, and my lord, as a member, my lord, the writ petitioner kept quiet. One person is putting a spanner in the works. he kept quiet. The election procedure started. My lord, the voting, my lord, the entire plan for voting, my lord, election, that was also published. Then, my lord, just before election in the month of January 2026, he has made this writ petition. I am taking this preliminary point that this writ petition is not maintainable because already the election procedure has started and therefore the matter.
Cite any decision on that?
My lord, I have got this before lordship. In a hurry, I could not. I shall just give your lordship, my lord, the reference, and I shall give a copy to your lordship. My lord, this is that famous case of Tomar. Yes, Charan Singh, right? Give me 1 second, my lord. Dharo. Over. Give me 1 second. কাগজটা কোথায় গেল? Yes. My lord, this is.
আমি তোমাদেরটা নিয়ে আসছি ওটাই বলবো তো
না কোথায় এই যে 2006 8 Supreme Court cases 352.
Yes.
Ishan Singh Tomar. The judgment of my lord, a constitution bench, Chief Justice Sabharwal, KG Balakrishnan, Kapadia, Thakkar.
You have a copy of that?
My lord, I shall just hand up to your lordship this one. Thankfully, the condition is good of this book. I tell you, lordship, what happens is this. In fact, we are taking steps now in the Bar Library Club. What the members used to do, unfortunately, I don't want to sound obstreperous in this. They used to take them to the round the corner for the purpose of xeroxing. And once you xerox these books,
that pressure is being put,
pressure
that
is being
binding
put and
gets,
immediately.
and those teaching from that
Absolutely. So, my lord, now by rules, my lord, we have stopped doing that.
The other things, Mr. Mitra, you will be finding some pages, some important decisions from the reports is not there. Relevant pages of that important.
They've been taken off. Very dangerous, very sad state of favor, particularly from amongst advocates. If that happens, that's very unfortunate. And this is total lack of consideration for others. That's all that I can say. But now, my lord, perhaps the things have improved because, my lord, these are
Nowadays,
all
rarely
obtained.
one takes
Yes,
these
that's
copies.
right. Now, my lord, online they can be had.
Yes.
এটা দিয়ে দাও। My lord, in fact, my lord, Supreme Court has said exactly what should be the law. That once the matter has gone into the realm of election commission, then election commission is the person who should hear the matter.
I think in one of such decisions, it has been said that if this type of decisions are entertained after the commencement, then no elections can be held.
No election can be held.
I think that's the exact language which has been
I
used
think
in
here
one of the
some kind of indication is there. I shall try and find out more others. I had the occasion to, my lord, appear in the matter. My lord, quite a few decisions were cited. In fact, my lord, starting from it's a long Punaswamy's case.
Yes, that's the parent judgment.
That's the parent judgment. From Punaswamy's case, thereafter all these judgments have come. তুমি আমায় শিখিয়েছো. In fact, my learned friend was my junior in the matter.
Well, the round law has developed and court is observing that immediately after independence, election was being held in a manner, and now there are changes in conducting election. Therefore, court can interfere.
That's the unfortunate part of it.
Yes.
Yes, my lord, there is only one other thing that I say, that whether election or no election, my lord, really this kind of dispute, there is a provision in the Act itself why should your lordship, my lord, allow your lordship's record to be unnecessarily weighed down by all these litigation?
After all, it requires a factual adjudication.
Factual adjudication, number one.
Whether that list was prepared in accordance with law, not in accordance with law. So whether it requires an adjudication on facts.
And my lord, when an alternative statutory forum has been provided in the act itself, my lord, kindly take my lord 102 once in this kind, section 102.
Section 102.
Section 10, just once, my lord, kindly see. This will make it very clear as to what is what was intended by the legislators. Disputes to be filed before registrar. Any dispute concerning the management or business or affairs of the cooperative society other than the dispute relating to election in a cooperative society as and when such election is conducted by the Cooperative Election Commission, in our case, Cooperative Election Commission, and disciplinary action taken by the cooperative society against any paid employees regarding. So, my lord, any dispute other than, my lord, election dispute will go before the registrar. The election dispute will go before the election commission. These are my observations.
Yes, Mr.
Let us first take our statutes, 2006 Act.
Yes, 2006 Act, yes.
Section 3.
Section
3.
You start from section 3.
Yes, because the basic principle is there.
Yes.
The following shall constitute the cooperative principles, the basic principles. Now, clause 2. The cooperative societies are democratic organizations controlled by their members who actively participate in setting their policies and making decisions. Their affairs shall be managed and administered by the person elected or appointed in a manner agreed by the members and accountable to them. Every members of the cooperative society, other than nominal members, this is important, shall have equal right. The nominal member does not have equal rights of voting in accordance with the principles of one member, one vote. Therefore, the members of the society will decide the policy, and whoever in the the democratically elected board will decide, and they are accountable to their members.
Yes.
Now, section 4, subclause 41.
Section 4,
subclause 41.
41. Yes.
Definition of member. Member means a person joining in an application for registration of a cooperative society or a person admitted to the membership of the cooperative society after registration in accordance with the provisions of this Act and the rules and the bylaws made thereunder, and includes a joint member or self-help group and subject to the provisions of subsection 3 of section 63, a nominal member. Nominal kind takes up section 63.
63. 63 subsection 3.
Subsection 3. Section 60, and senior friend has referred me. I'll be referring subsection 3.
I'm at subsection 3.
Notwithstanding anything to the contrary contained elsewhere in this Act, a cooperative society may admit an application, any person, any association or body of persons, whether incorporated or not, as a nominal member, who shall not be entitled to any share in any form in the assets or profit of the cooperative society, and shall not be eligible to be elected as director of the board and shall have no right to attend the general meeting of the cooperative society, but shall have such right and privilege and shall be subject to such liabilities of a member as may be specified in the bylaws.
How do you decide who will be the nominal member, who will be the-
Bylaws. Now, kindly takes a bylaws. This amendment was introduced in 1996.
So this bylaws do not contain that. The Mr. Mitra's.
Namlet clause 6.5.
Yes.
6 Roman 5. New clause to be inserted: any person above 18 years of age and working under the IOC Haldia division may be admitted in the interest of the society as nominal member on payment of the entrance fee of ₹10 on the following terms and conditions. Then, a nominal member shall not be entitled to any share in any form whatsoever in the assets and profits of the society, nor shall have any right to vote in the affairs of the society, nor participate in the management. Not what more I require. The elected body of the society.
No, how do you decide who will be the nominal member, who will be the?
Admittedly, they are saying, I don't decide. They themselves.
Consideration. Who will be nominal member and who will be the ordinary member?
That the board will decide. That the board.
On what basis?
Elected board will decide.
On what basis?
That what?
Please show me the basis of deciding who will be the nominal member, who will be the other members.
But with all due respect, of the main bylaws.
Main bylaws. I have the main bylaws. Clause 7. Yes. Yes.
The society shall not admit new members, transfer shares, existing members within 30 days from the date fixed for holding annual general meeting, the election. Then a copy of the application shall be hung up on the date of its receipt by the society on its notice board, written objection, if any. And then clause B. An employee of the society who is eligible to be its member shall, on application made by him, be admitted as a member of the society, but shall have no right to vote. Then C. Every person desirous of becoming a member shall submit an application to the secretary in such form as the board of directors determine. The application shall be supported by at least 2 members. The board of directors may, after consideration, admit the applicant as member or refuse the application for membership. This is the procedure mentioned.
Tamlat persons were nominal members.
Yes. Admitted.
Please show me how they were nominal members. How on what basis they were made nominal members?
This is undisputed. They themselves have said that they are nominal members.
Yeah.
And
as they have said.
Kindly take some affidavit of 5 and 6.
They have made an application for being admitted as a member.
Let us first take some page affidavit of.
I think they made some applications when the previous board was in session for being admitted as a member. What was the decision on that?
On the last occasion, my learned friend submitted an affidavit to demonstrate that it was refused and no appeal.
On what ground? Was it said with regard to anything with regard to nominal member?
That their membership, as partnership, shareholding capacity was refused by a elected board.
Why? On what ground?
That is not subject matter of challenge. That is an
asking you on what ground may not be the subject matter.
I don't know. I was not served with that order. I do not know.
And on what basis they were made nominal members? What's the
by their application?
Who will decide who will be nominal member? Who will be the other members?
But that is bylaw.
Decide that.
Bylaw.
What's the basis of deciding
Board of
it can be at the sole discretion of the board.
Yes, yes, yes.
Some
Maybe
that
subjective.
discretion
Maybe
left with the board.
that's what the procedure I have shown.
No, it does not say on what basis.
No, basis, this High Court cannot decide, but it can be decided.
Who can decide?
But decide by the elected board.
All right. Let the board come, they will decide.
Yes, ma'am. That's my point. That the elected board can always decide that I will not accept this member, I will accept it. Because ultimately it is
Accepting the if a wrong decision is taken by the board.
They can challenge it.
Before
64, section 64, Millet. Section 64. May I read? This is a relevant question, Millet.
Please, all of you, if you argue
Action
that
সবাই
it
বললে
cannot be finished. Yes, yes.
Kindly take some section 64 once.
Yes.
সবাই একসঙ্গে মিলে কথা বলে কোর্টকে বোঝাতে পারবো না। If anybody whose application has been refused for whatever reason.
No, 64 deals with which member?
Member, any form of application.
Nominal, other things. So it does not distinguish between nominal member and other.
No, it's a appellate power challenging the decision, refusing membership.
64 deals with admission of a member. It does not say nominal member or other members.
The provisions I have shown to your lordships, the distinction there is a nominal member and shareholding member.
You are trying to distinguish nominal member do not have a right to vote, do not have a right to
The statute says.
In the decision making. So what's the procedure for admission as a nominal member and other members? Show me that distinction.
As of now, I have shown section 3, definition clause, section 63, only to demonstrate.
No, Mr. Ahmed, I have understood the difference between an ordinary member and a nominal member. My question to you is, show me the provision for admission as an ordinary member, admission as a nominal member. What's the distinction? If an application is made, who decides on what basis? Because there has to be some criteria. This criteria, nominal member satisfied, yes, he will be a nominal member. No, he falls within this criteria, he will be an ordinary member with a right to vote.
I'll answer each and every question of your lordship. But before that, 2-3 lines. First, the petition was filed seeking cancellation of the list published by the Election Commission on the ground that these members are nominal members, they do not have right to vote. The decision of the special officer to admit those as shareholding member is beyond the jurisdiction of the special officer. That is my subject matter of challenge. Therefore, the issue involved in this petition, first, whether the writ is maintainable, challenging that decision of the special officer admitting as shareholding members. Second, whether a special officer has at all jurisdiction to take a policy decision as it has taken. So these are the two issues. Now, to demonstrate that, I have shown to your lordships that yes, there is a difference between nominal member and the shareholding members. Therefore, the rights that they are claiming that bare ministerial work done by the special officer to justify their action. I'm sorry.
It happens in election.
No.
Yes.
To demonstrate.
Something on lighter note. Don't take all observations serious. Yes.
But the right of I was trying to demonstrate that it's not a mere ministerial work, rather it's a policy decision because it changes the entire democratic system of that particular cooperative society. Who will be voting for the next board will be decided by the members. Therefore, who will be admitted as members having voting rights is a policy decision, cannot be taken by the special officer. Therefore, as of now, the undisputed fact is that these members who were admitted as shareholding members admittedly by the special officer is illegal, since the special officer does not have jurisdiction to take a policy decision. Now, kindly takes up. না তার আগে আমি আগে রিট পিটিশনটা দেখিয়ে নিই, যেটা রিট পিটিশনে আমি যেটা অ্যানেক্স করেছিলাম, আমি যেটা বলছি সেটা স্পেশাল অফিসার নিজেই বলেছেন। এই ইয়েস ম্যাম, পেজ 35. Yes. It's a policy decision and cannot be taken by the special officer. Therefore, admission of those members as shareholding members is illegal, has in fact stated by the responsible officer of the state. This issues was my assistant returning officer, 3rd July 2024. You are aware that I have been appointed assistant returning officer for holding election of the delegates, board of directors, office bearers of Wholesale Employees Welfare Cooperative Society Limited, vice versa. In view of the above, for the purpose of updating electoral roll, I would like to publish the voter list, inviting claims and objections, if any, as early as possible. So I would like to request you to provide me the said member list, list constituency wise, as delimitation done for the said purpose at the earliest. It may be stated here that no admission and no transfer of shares of members should be take place till assumption of a charge of a new board in terms of Rule 18 of the 2011 rules. Therefore, the responsible officer of the state themselves has said that no, we don't have right to admit any new members.
Yes.
Now, following this principle, in fact, these principles were settled by our High Court also. The last question I had cited judgment of our High Court passed by coordinating bench, citing the judgment of Karnataka, passed by the Supreme Court. Now, before that, this is from the affidavit of Biplab Das. It's 5 and 6.
5 and 6.
Yes.
Your Lordship, I am for the special officer. My affidavit be taken on record.
Oh, you are 5 and 6.
Your Lordship. I am the mischief maker.
Let me see. Yes.
At page 45. Yes.
Yes. Page 45.
As per your directive, I, the inspector of cooperative society.
Page 45.
45.
Yes. Yes.
So also block, development block, inquire on 6th December 2022 at the Register Office of Haldia Cooperative Credit Society Limited in presence of the petitioners and the board members of the above mentioned society. I covered the particulars which are portrayed in your communication via memo dated 2021. All findings are given below. To the point wise, after verification of all requisite documents associated with the above mentioned society, and also from conversation with the board members and the petitioner, it is evident as per shared register, the total number of share members are 449, and the member register total number of 1021 members are entitled to, are enlisted up to 6th December 2021. That is 449 share members, 572 nominal members. The answer to your Lordship's query. It is conspicuous to me that there is discrepancy between the share register and the members register, as there are included many retired members, because it was not updated after retirement. transferred members, that is Swanso has been retired. Then let after few lines, last office bearer selection was held on 17 March 2017. After observation all requisite documents regarding election and conversation with the board members, it is conspicuous to me that there is division among the ECCS members in the society in two ways, that is share members and nominal members. Therefore, this is undisputed. In fact, the respondents, answering respondents are also not disputing that there is difference. All they are submitting that the special officer has done the ministerial work. There is no policy decision. Now, this has been decided by the I will say assistant returning officer in his letter date 3rd July 2024. That is a policy decision and only elected member can.
You are relying on this document.
Yes, nobody has challenged that. These are unchallenged documents. Therefore,
so that is why I am asking you once again. You are relying on this.
When your Russia says, in a manner, I apprehend some more question will come from that.
No, I will not put any question. I am only asking you whether you are accepting this document or not. Yes or no, because you must have read many times. I am looking at this for the first time.
No, but I have relied on 3rd July 2024. Not so far.
No. This you are placing page 45.
No, page 45. I have referred this only for the purpose of to demonstrate that there is demarcation.
You are not relying upon this. You are disputing this.
To demonstrate.
I am asking you, are you disputing this or you are relying upon this?
The rest part
you will
again.
You will admit one part, you will discard another part.
Principle
of a
against
particular document.
Principally appropriate.
So that is why I am asking you. Please take a decision whether to accept or not to accept that.
You
have not answered that.
No, yes, I am answering. My answer is that whatever conclusion drawn, I am not on that. But the facts, the decision, I am not on that. This decision was never communicated to me. But in arriving this decision
is against you.
This decision ultimately resulted in their inclusion. I challenge the whole process.
The decision is against you.
May I read the decision once? The program of the nominal members has no right to their.
The society management is giving logic.
Yes, the society management is giving logic that only shareholder members have right to participate of the election program and nominal members has no right to their voting programs. This is not maintain consistency in terms of the ECCS of the above mentioned society and violate West Bengal Cooperative Society Act 2006 with respect of chapter 6 member of the cooperative society and their duties, rights, accountability, privilege and liabilities under section 63 subsection 2 provided that an employee member of an engineer, labor, industrial scenario, transport and cooperative societies shall have right to vote at an election of or for being elected as director of the board or delegate to any other cooperative society. I mean to say, I have observed the division among the members. Share members enjoy all types of facility, including voting right. Nominal member enjoy all types of facility excepting voting rights, whereas the area of membership as per bylaws of the said society is permanent employee of IOCL Haldia division. I request you for taking appropriate steps so that all permanent employees, members may get voting rights in the next forthcoming election, which will maintain consistency with ECS principles as well as bylaws of the said society. All permanent employees of IOCL Haldia division will help to maintain peace and harmony among all the members. Therefore, this is a request made by the officer, my lord. Now, my lord, I am not on the last part.
You are on the first part.
Now, the last part is a request. Last part is a request on the basis of admitted facts that there is a distinction between.
I've got your answer. Yes, you can proceed.
Now, my lord, this request, my challenge is in my petition is that based on this request or whatever, for whatever reason, my lord, acceptance of nominal member by the special officer. Again, my lord, I come to that my point.
What is the hierarchy? Inspector of Cooperative Societies and Assistant Registrar of Cooperative Societies.
That they can not have.
Yes, Mr.
He
Nayak.
is subordinate to Assistant Registrar of Cooperative
Who
Society.
is subordinate?
Inspector is subordinate. Inspector has written to ARCS. ARCS has given direction to the secretary.
Cooperative societies, then cooperative development officer, then ARCS.
So there is a hierarchy in hiring post.
That is by ARO.
And even if
that is by ARO, not by ARCS.
Yes. But I don't insist on the issue whether who is hired to the post. Rather, I am on law and the fundamental law. That whether policy decision can be taken by the special officer or not. That is the fundamental point.
You can come to the fundamental point now.
Yes, lad. Now, lad, I'll be citing lad a judgment of 1997 6 SCC 37 lad to demonstrate that how to lad respect the bylaws. Oh, special. Boss.
Proceed with the powers of the special officer.
Yes.
Then you can cite that.
Yes.
1997 6
SCC page 37.
37.
Yes.
Yes.
Watch our judgment.
Now, paragraph 4. Paragraph 4 quotes the relevant provision of the statute.
Paragraph 4, yes.
Paragraph 4 starts from page 38. Now, kindly takes up page 39. It quotes the provision.
Appointment of special officer.
Yes. Number relevant is clause 3. The similar provision we have in our statute. The special officer shall, subject to the control of the state government and the registrar, exercise and perform all parts and functions of the committee of the cooperative society or any officer of the cooperative society and take all such actions as may be required in the interest of the cooperative society. Now, I'm kindly takes up our provision. Okay, bolo bar kar do.
Yes. Which section?
36.
36.
Amlet, clause 2 is appointment. Clause 2 is appointment. Subclause 2 is appointment. And subclause 4B. না হয়ে এসছে 15 minutes more. No minute maximum. But subclause 4B. I'm not reading it. Similar provisions with similar powers.
This place the similarity. Indicate the similarity. Indicate the similarity.
Subject to the control and
This matter will continue. Others matter may be released.
Ask them. I do not know how.
Lordship, I will also be taking some time. I am appearing for the special officer. I will be taking some time.
At the time of starting of the matter, I have also made my submission relating to the increase.
Let me see. Yes.
subject to the control and direction of the registrar. Now, my lord, here, my lord, special officer shall subject to the control of the state government and the registrar, and notwithstanding the preferring of an appeal under section 147. The special officer shall exercise all powers and perform all duties which may, under this act, or the rules or the bylaws, be exercised or performed by the board.
What are the duties of the board?
Duties of the board or any officers of the cooperative society.
What are the duties of the board?
32 let. Lad, there shall be a board of directors of every cooperative society to manage its affairs, and the board shall consist of such members and directors as may be specified in the bylaws of the society. The directors shall include in the board the following members, manners. Manage the affairs of the society.
Yes.
The moment all actions will be taken by the special officer in the judgment I have cited. All actions. The judgment I have cited, the statute says all actions of the cooperative society as may be required in the interest of the cooperative society. Therefore, it includes all actions of the society.
Yes.
Therefore, the judgment I have cited, the provisions is special officers have the all powers. All powers. This has been interpreted in paragraph 8.
Yes.
Let's come from paragraph 5. Made it. It would be clear from the language of these provisions that the administrator or a special officer subject to the control of any of the functions of the society and in the interest of the society can take such decisions, such actions as is necessary for proper functioning of the society as per law. He should conduct elections as is enjoined thereunder. In other words, he is to conduct election with the members as on the rolls, and by necessary implication, he is not vested with power to enroll new members of the society. Then clause 8. Sri Hegre, Senior Counsel, contends that since the administrator has power to conduct elections by necessary implication, he has power to update the electoral list by the either enrolling new members or substituting legal representatives of the members in accordance with the bylaws. Therefore, he has power to enroll members. We find that there is no force in the contention. The power of administrator given under the statute to conduct election should be confined within the parameters set under the relevant provisions of the Act, rules and bylaws. The division bench has minutely and carefully gone into the questions and agreed with the learned single judge that the administrator has no power to enroll new members, but he has the power to organize election process in accordance with the provisions of this Act, the rules and bylaws of the society. In that view of the matter, we think the High Court has not committed any error of law warranting interference. But kindly visualize that it's a cooperative society.
Please kindly come to subparagraph of paragraph 7. But the distinction between the Kerala Act and the Karnataka Act has been pointed out. Please read that.
Division bench, after elaborate consideration, has agreed with the above conclusion reached by the learned single judge and held thus. Accordingly, he is not entitled to enroll new members, but it has to be noted that the wording of section 33(2) of Kerala Cooperative Society Act is slightly different from wording of section 30 of the Act. In Kerala Act, the administrator has power to exercise all or any of the functions of the committee, whereas Karnataka Act, the administrator can only exercise all or any of the functions of the committee. Moreover, as stated earlier, the difference in the authority vested in an administrator and a special officer and is made in the Karnataka Act is not considered in the Kerala decision. The difference in the authority vested in an administrator and the special officer in the Karnataka Act is very significant, which is absent in Kerala Act. In that view of the matter, the dictum laid down in the division bench of the Kerala High Court cannot have any application while determining the comparative authority of an administrator and a special officer appointed under section 30 or 30A of the Karnataka Act respectively. In view of what is stated above, we confirm the decision of the learned single judge and dismiss this appeal. The direction regarding the election given by the learned single judge shall be carried out by the respondent concerned within 2 months from the date of receipt of the copy of the judgment. Now, this does not, this deals with other act. But I have referred the provisions of a statute which has been considered by this judgment and has drawn a conclusion. And this provision is similar to our provisions. Therefore, I don't mind what is there in the Karnataka.
Kerala Act.
It is in the Kerala, I'm sorry.
Karnataka is similar to.
Now, forget about all this judgment. Now, why this judgment? Why the principles I have shown, the section 3? The reason behind is that ultimately it's a democratic setup. If the appointed officer, in a democratic setup, it's the obligation of the elected board to conduct election before expiry of the tenure, so that no such officers
control of the last elected board.
We are the members, shareholding members. We are not. We are not.
One writ petition, I think he's one.
Maybe they may be. We are not. But I'm on the principle. It is the duty and obligation of the last elected board to conduct election. Because of their failure, the officer was appointed to conduct election, and he was given powers so that society runs. That does not include the policy making decision. If that be so, then the entire objection.
Mr. Ahmed, according to you, is the what should be the members list according to you? The members list as on the last elected board, minus those who have died or expired.
As on the date of expiry of the elected board.
Yes, that is what I am saying. As on the date of expiry of the last elected board, minus those who have died or who have transferred.
Yes. As specifically observed by the assistant returning officer.
Let's take a case where for 30 years no election has been held. For
we cannot
more writ petitions, litigation.
We cannot.
No, I'm asking you.
We cannot apprehend that Mr. Modi will continue as Prime Minister for since 30 years.
Mr. Ahmed, I'm giving you an example. Let us not go 30 years back. Let us go 15 years back. So, elected board was there. So, only that, as on the last date of that board, was the members. Thereafter, for 15 years, the members do not have any right. They can not come in. They cannot go out. Then there is also no use of publishing the
electoral roll.
Yes, because the last.
I understand. What is
no use. So there should not be any.
I understand, Lordship's apprehension. What is falling from your Lordship, I could understand that.
Cannot be any. There cannot be any preparation of the electoral rolls.
That's why, we are vigilant. We don't want for this officer to continue managing these affairs. And we have come forward before this court, restore our democratic right.
Cannot be restored.
Restore our
Cannot be restored.
by
Cannot be restored.
One single
Right.
person referring as we.
Because no electoral roll can be prepared.
At the instance of one man.
Referring as we.
There is no necessity. I'm not saying no electoral roll can be prepared. There is no necessity of preparing an electoral roll because last electoral roll was there when the last body was.
kindly see the provisions.
Whoever was entered into as a member, that is there. So after that, he's disturbing. Yes, Mr. Bisar, why are you disturbing?
Javed Miyadandlet.
The senior is there. Mr. Shanal, please take care of it. Yes. Yes.
The provisions of the statute, the appointment of a special officer is for the purpose of conducting election. And the directions of the statute is that he has to
Special
conduct.
officer is continuing from 2022.
Yes. No, but I'm not on that.
Till 2026.
The purpose.
One term of an election is almost
The
over.
purpose of appointment is to conduct election within 6 months. If it is beyond 1 year, then special officer cannot even continue. Then nominated bid will come. And again, the duty is to conduct election. Here,
purpose is same. Nobody, either nominated or special officer, can conduct an election.
No, that's my submission is that the special officer can continue for a year, for an extended period of 6 months more, for conducting election. If he fails, then nominated board comes again for conducting election. So, for conducting election, the cutoff date is the expiry, because on the date of expiry, new board was supposed to come and take over charge from the old board. Therefore, the cutoff date, the question that has fallen from your lordship, that what would be the cutoff date, who will be the member will elect the new board, is that the cutoff date within which whoever has got the right of voting. I believe that I have made myself clear that whoever joined as a shareholding member on the last date of expiry of the tenure.
Where is that law?
Because the elected board will manage. That's the law. Now, for some reason, election could not be held. Therefore, on the day expires, the new board was supposed to take over charge. Because of failure, the special officer or whoever in the charge, interim, unelected, cannot take policy decision. That's the fundamental question. Therefore, the cutoff date is the expiry of the tenure. That's my submission. Now, the yes, now, I had cited this judgment of our coordinate bench. But it was in WP 266 of 2019.
Same principle.
Same question was arisen, and court has answered.
WP
266 of 2019. 15 January 2019. I can recall before Rashid, possibly I faces difficulties because there was a coordinate bench judgment. Court has said since there is a coordinate bench order, I cannot touch. Since there is a coordinate bench order, Rashid cannot touch. Possibly I have in a matter, civil division matter, possibly Barashat Eye Hospital or something.
Barashat Eye Hospital decided by the Honorable Supreme
No,
Court.
I had cited that possibly.
What? It's by the Supreme Court.
Yes. Now,
it's not by the coordinate bench. It's by the
no, it's from this court.
Yes.
And when the question had arisen that whether the similar principle, when decided by the coordinate bench, can again be decided by the other coordinate bench.
Mr. Amit, do you have another copy? Because I don't.
Oh, yes.
Copy.
Mark করা আছে।
It is marked.
This will help me, those which are against you. Because you must have marked the portions against you.
This is totally in favor.
Well, I think the entire order is in my favor.
The entire order is in your favor. Yes.
Whatever.
Well, I am just reading the relevant part.
কথা না না।
Page 5.
Yes.
Well, kindly take some page 3 first. From the middle, the contents of the petitioner is not devoid of substance.
Which page?
Page 3.
Page 3. Yes, page 3.
The contention of the petitioner is not devoid of substance.
Yes.
One cannot but notice that an administrative order cannot be used as an indirect route to amend a statute and consequently frustrate a judgment of the Honorable Supreme Court. One could have obtained amendment to the statute or an ordinance introduced in this regard. The same has not been done. Hence, in my view, an administrative order cannot in any way dilute or change the object and purpose of a statute passed by the Register of the Cooperative Society. This court has no doubt in its mind that the said order has been passed to bypass or to frustrate the effect of the order of Supreme Court in cases of T.A. Kuttapam. The said order dated 7th August 2018 of the Register shall not be of any effect and is hereby stayed. The Learned Counsel for the Election Commission also submits that the electoral process has commenced sometimes in September 2018 and the petitioner and other persons has raised objection to the same and some of them has also filed nomination, hence are debarred from challenging the process of election. I have considered the same and find that the writ petition has been filed after the objection of the petitioner and many of others persons has been rejected by the Cooperative Election Commission and final list was published on 7th December 2018. The writ petition was affirmed on 18th December. There is therefore no delay at all on the part of the petitioner in agitating the grievance in question. The next argument of the Election Commission is that there is only one person who has challenged the election process and that in the spirit of the Cooperative Act of 2006, the wishes of the majority must be deemed to have prevailed and one person cannot upset the election process of a large society having a large number of members when the other members have not come up agitating the aforesaid grievances as contained in the instant petition. This court cannot lose sight of the fact that the members of a cooperative society, particularly an agriculture cooperative society, may not wish to be burdened by litigation and participating in judicial proceedings. Even if a single person is coming forward before the court of law and complaining of gross illegality, which is evident in this case, the court cannot shut its eyes simply because the majority of the members have not approached the court. In view of the matter, this court is satisfied that the writ petitioner has made out a strong case for interference by this court. None of the members inducted by the nominated board shall be allowed to participate in the election process except those who were present in the roles of the society as members prior to taking over the nominated board. This court is more inclined to pass aforesaid order as there is clear attempt to frustrate not only the order of the Supreme Court but also aforesaid order dated 21st December 2018. The Learned Counsel for the Election Commission has referred to a decision of the revision bench of this court in similar circumstances being 30th October 2018 passed in MAT so and so, wherefrom an order preventing the members inducted by the nominated board from participating in election was interfered by with the division bench, permitting the person to participate in the election process of election. That the dispute as regards their induction by a nominated board would abide by the result of the appeal was filed challenging the process of election. I am of the view that there is a difference in the facts of the case before the revision bench and the instant case. The instant case, a single judge had already ordered election to be conducted within the period of 10 weeks from the 1st February 2018. Continuation of the nominated board of a board of assistant registrar of the scope of society. Extension thereof is, according to me, a clear attempt to frustrate not only a specific order passed by the coordinate bench of this court in respect of the same society, but also an attempt to bypass and frustrate the order of the Supreme Court referred to above. Hence, this court directs the assistant registrar of the cooperative society shall finalize the voter list essentially based on the members who were present on the list of the society immediately prior to taking over the nominated board, and the election shall be held according to.
This is against you, Mr. Ahmed. Not as per the members who are on the rolls as per the last elected body.
Then?
Last elected body, thereafter the nominated board.
Oh, yes, court has
said, as on the last date of the elected board. It's the nominated board.
No,
not in your...
court has observed that.
You said the last elected board.
Yes. I still say that.
Last elected board. It's the nominated board. So it does not support your contention.
No, it supports my contention.
How?
It supports my contention because
the date nominated board was appointed after the date of the last expiry of the last elected board.
Right.
So those members were also allowed to.
No. Court has observed that prior to the taking over of nominated board.
No.
Yes. Prior to taking over of the nominated board.
Please kindly come to this.
Page 6, second last paragraph. Second line.
Relief portion ta bola clear hol. It is made further clear. Members inducted by the nominated board.
It is made further clear that the members inducted by the nominated board may continue such member after election is complete with a member who were present on 1st February 2018, being date of the order passed. Therefore, court has observed the nominated board, whoever inducted cannot have right to vote. Whoever inducted
prior nominated board is constituted.
Huh?
When a nominated board is constituted.
Section 29,
Madam,
7.
When the nominated board comes.
The principles that has been decided in this court.
I'm asking you, when the nominated board comes.
It may be immediately after the board was, but there are orders passed by the, I have done cases where the nominated board was appointed immediately after the board was over. But there are factual differences. But the principle is unelected board doesn't have right. Unelected officer. That's the principle, fundamental. That is the Supreme Court, which is cited, and following that principle, court has observed that. This is in my favor.
Yes.
Now, the question of maintainability was raised, that election is. Again. Now, I was. Oh, sorry. Printout nahi? But one judgment may I read, I don't have the copy of it. That bylaws has to given credence.
For what purpose?
Here, they have the special officer has violated bylaws also.
Why?
How? Because nominal member doesn't have voting right. He has given that is his affidavit also.
Affidavit, they have admitted that they are nominal members. Where from do you get their nominal members? Please show me that facts first.
That I have read that letter, page 45 of his affidavit, where he has made a request.
Only one thing, page 45 says there are two disputes. One is shareholding members, one is nominal members. Whether these persons who are included in the list, whether there was nominal members, do you get that?
Yes, man. That your lordships can get from my annexures when they have admitted to as member.
No, that they have admitted as nominal members. Please show me that document. Recognizing them as nominal members. Please show me that.
I can demonstrate that this member were joined as member in the list, shareholders list, on and from this list, these days. This is undisputed. Therefore, prior to that date, they were not shareholding members. Therefore, in terms of law, there is other option is nominal member. Am I made myself clear, Vlad? The date I have mentioned undisputed that from this date they have become shareholding member.
ওদের এফিডেভিটটা না প্যারাগ্রাফ 5 পেজ 5 পেজ 5
বলছো না কেন
ওদের এফিডেভিটটা না they have
blood
indicated
their affidavit.
I want to know that.
page
Please show
5
me that.
Which affidavit?
Affidavit by respondent numbers 7 to 26. Which paragraph?
page 5 sub paragraph 4 joined on amok they made an application on amok আর ওদের মেম্বারশিপ দিচ্ছে 2024 that is admitted তার আগে কি ছিল
Yes. The respondent number 7 to 26 immediately after joining the service of IOCL on different dates. More specifically, the respondent number 7 joined on so respondent number 8. These are dates of joining.
Yes.
made applications for membership on the different
Where do you say that they have admitted
Then
that they
blood,
have become nominal
after
members?
submission, IOCL started deducting so and so.
এই করে বাবা এটা হচ্ছে ওদের ডেট অফ জয়েনিং নমিনাল মেম্বার তারপরে
Where from you got this nominal
ওই
member?
ডেটটা কিসের তার
Let me answer my way. Namlet, in my petition, I have annexed the list at page 83.
Page 83, yes.
It is pleadings bar kor page 83 annexure P8 annexure pleadings tar denial ta bar kor.
Page 83. Yes.
Now let kindly see these they have not disputed that non-shareholders who had joined as shareholding member last right hand side column on these dates. They were not prior to this date, they were not shareholding members. There was other option left is nominal member, which they have
Do we get that? I do not get that, Mr. That's your argument. That
No.
Other, please show me any document. They were nominal members. From nominal members, or you have to show yes, initial membership will be nominal. Thereafter, ordinary members, shareholding members. How do you get these things?
let them produce the
From the very beginning, I am asking you to demonstrate this. It's not clear to me, these two concepts.
Well, may I, I'm sorry to have to interrupt my learned friend. Kindly excuse me.
Yes.
I was just wondering, kindly see my lord section 63, which I placed before Lordship 1. If one becomes entitled to become member under section 63(1), then there is no question of subsection 3 coming in. Subsection 3 is notwithstanding anything contained, the cooperative society may admit. This is an additional power of to admit as a nominal member. And my lord, this will be clear if your lordship panel looks into section 64 subsection 1. Any person eligible for membership under subsection 1 of section 63 may apply to the cooperative society for admission as a member thereof in the form and manner prescribed. Now, read this along with rule 107.
Because 64 does not make any distinction between nominal and other members.
Exactly. But my lord, kindly see my lord, now read my lord section 1, rule 107.
Rule 107.
7, very important. If these three sections are read together, 63(1), 64(1), and Rule 107, then my lord, there is no question of a nominal member. One becomes entitled. It should be in that book itself. Judge সাহেবের সামনেই ছিল।
সেটা বলো কোর্টের আনসারটার জন্য ঘুরিয়ে দেবে না।
Not there, my lord. I think it will be in the lordship table.
It was yes, after rule
107, kindly see.
Yes, 107.
লেখা আছে
Eligibility for membership. No person qualified to be a member of a cooperative society under the Act
nominal member ছিল ওটা তুমি ছিলে না
or the rules or the bylaws shall be excluded from membership.
প্রুফ করো
So, my lord, if I am qualified to be a member in terms of section 63(1),
you cannot be
I can't be as a matter of course I become a member. Then my lord, nominal membership question right. That is a discretion given to the my lord, under section 63. That's a additional power given to the board. Cooperative society may admit.
Who will become nominal member? That's
an additional discretionary power given to the board. I suppose, my lord, some person who is
not falling under the parameters of becoming the member, Your Lordship, for the
Section
time being
62 part.
requires the credit facilities. For instance, a person is not entitled to become a shareholder member of a cooperative society, but is in need of credit. So for that purpose, for short term, that person is admitted as a nominal member. So there is a relationship created between the cooperative society and that person to grant that loan.
Be a permanent employee of IOCL.
Your Lordship, once he is a permanent employee, there cannot be any reason to exclude him from shareholding membership. If he completes, I shall for the special official.
Yes, Mr. You can make your new rule.
So many oppositions are still. But page 38
yes.
is the
38 of your writ petition.
Yes.
Yes.
Basis of my case. 8 paragraph the part for opposition. Private respondent as well as state. Is page 38 is Malad.
আমাদের ফেভারে আছে ওটা আমাদের ফেভারে আছে দেখিও না আমাদের ফেভারে আছে আমি তোমাকে দেখাচ্ছি
Reading sir. Reading the
Can one made by the applicant who added to the party in 4549. They have enclosed the entire list of members who were nominal members and wanted to be members of the society.
Who were nominal members?
In can 1 of 4549.
Admitted আছে
Yes, Mr. Ahmed. All right, yes, Mr. Ahmed.
Kings কোথায় nomination claim করেছে Namlad in their affidavit page 46 but page 46 of the affidavit kindly comes Namlad respondent number 2
Page 46
yes
of the writ petition
of the affidavit of the
respondent number 2 of the respondent number
2
7 to 26
just a second
5 and 6
5 and 6
Vijay Verma would have
5 and 6 বলছি
না 5 and 6 আছে same documents is also is there page 46 of 5 and 6
Also there in can 1 4549. At page 32.
Now kindly read this letter along with my objection.
Which letter?
Page 46 of the affidavit.
Of the
Affidavit of respondent number 5 and 6.
Of the affidavit of the respondent number 5 and 6. Where is that?
Page 46. This is
Mr. Sureka's affidavit.
No, he is referring to my
No, page 46 and not my affidavit. Can't be.
No, Mr. Sureka's.
respondent number 5 and 6.
5 and 6, we have filed the affidavit.
Your Lordship, I have handed over the affidavit.
5 and 6.
I understand, my lord, in this tournament, Mr. Ahmed will not be maybe compelled to go out of the ground because tomorrow is the final match, election. Election commission has filed its objection also. I will be, my lord, having a little scope, my lord, to place my
Yes.
argument on the question of maintainability because every entire process is complete. So finally, wishing will not blow tomorrow.
Yes.
At page 46, I will
Let me see how long Mr. Ahmed continues with the match. Yes.
বুঝে গেছি।
Yes.
That
Hello?
His read petition has become infructuous, Your Lordship. On that score, then I have to
On
point
the
out the
same footing.
mentability.
You are also challenging the members list.
On that ground, I have to point out the mentability. He has no right to.
All right, all right. All right, I will hear you. Yes, yes, Mr. Ahmed.
page 46.
Then all right, I can fix it.
Day after
some days
tomorrow,
after,
Your Lordship.
I think it will be better.
Well, at
Because
page
it will be
46.
requiring some time to
If you are
address.
interested in making submissions, I can fix it after 1 month. No difficulty on that.
It's a hearing matter, Your Lordship has taken up on.
That will be held. Let that be held. That is why I'm hearing your petition has become infructuous. You are really standing on the same footing as that of Mr. Ahmed. He is challenging the voters list. So you also stand on the same footing and you want your application to be moved. All right, I will be posting it on a different day. No difficulty on my part.
I'm not wanting to move this application.
All right, please.
Your Lordship asked certain questions. Since I was the secretary, may I assist your Lordship?
I will come to that. Yes. Yes, Mr. Ahmed.
Now, kindly read this letter along with the letter
Page
46 of
Yes.
the affidavit of the respondent number 5 and 6.
Yes.
It's a letter dated 28th December 2021.
Yes.
Membership to eligible permanent employees of IOCL.
Yes.
It is learned from the report submitted by the Inspector of Cooperative Societies, Swanso, that there are 449 shareholder members, 572 nominal members in your society, as stood on 6 December 2021. Therefore, my lord, as on 6 December 2021, the number of shareholding member is 449. Now, my lord, kindly consider this with the final list and my objection. The number will be I have made the specific government. These are the nominal shareholding.
Page 46.
Yes.
Yes.
Now, my lord, before this court in this writ petition, the issue relevant is whether the final electoral roll contains this 449 or beyond that, more than that. If it is more than that, then it is defective. That's all. Now, my lord, in fact, my objection is in same line. I have shown to your lordships that objection I have made
against the draft voters list.
Against the draft voter list.
I've seen that. Given
And
the serial numbers, it takes more than half of the page. Then 6-7 lines thereafter. I've gone through that.
Now, whether I am now clear whether
So basically your submission is relying on that Supreme Court decision and other things. Whether this can be done.
Why now? Whether I'm
seen that.
Now I'm
I've read
clear or
that.
not. That so far, who are nominal members, I believe that I could make myself clear.
Yes.
Now, this voter list contains more than this number, and that is my objection I have raised. Last minute citation, I want to cite this judgment. Yes, of 2020 minute, whether court can interfere.
Yes.
2020 6 SCC 548.
6 SCC 548. Yes.
I must tell you, Lordship, that there are judgments in the same line and there are numbers, including larger bench decision, where court has held, and in fact, the observation in the line that post-independence, immediately after the independence, the situation and the present situation is different. And court has now considering rule of law also, within the election process. Now, kindly takes up.
Which paragraph?
Paragraph 14. 1-4. Rather, kindly takes up the facts first, then I am coming to the ratio of the judgment.
Yes.
But here, we have filed the petition before the election notification was issued, admittedly. Paragraph 1. This interlocutory application have been filed seeking direction for compliance with the constitutional mandate concerning election to local bodies. The late application, so is appellant in civil division, civil application number so wherein an order of Madras High Court refusing to issue certain directions to Tamil Nadu State Election Commission is under challenge before us. It is also the principal opposition party in the Legislative Assembly of the state of Tamil Nadu and is recognized state party. In civil appeal, DMK claimed that the party is, I'm not reading this, but this is the situation when, why before the Supreme Court, this matter has gone. Kindly take some now. 14.
Yes.
The contention of the respondents that the present proceedings amounts to calling in question an election and hence not being maintainable in view of the express constitutional embargo of Article 243O and Article 243ZZ does not impress us for the present proceedings are only to further the expeditious completion of the prerequisites of fair election. So ultimate objective is to ensure fair election.
Expeditious fair election.
Expeditious fair election.
Expeditious.
Expeditious and fair election.
Can be combined, Mr. Ahmed.
I'll take assistance of Mr. Mitra.
Yes. Yes.
Namlat, hence, the following ratio of a coordinate bench in Swanso squarely applies to the present case. Any decision sought and rendered will not amount to calling in question an election if it subserves the progress of election and facilitates the completion of election. Anything done towards completing or in furtherance of the election proceedings cannot be described as questioning the election. Subject to above, the action taken or the order issued by the Election Commission are open to judicial review on well-settled parameters which enables judicial review of decision of a statutory bodies, such as on a case of malafide, arbitrary exercise of power being made out, or the statutory body been shown to have acted in breach of law without interrupting, obstructing, or delaying the progress of election proceeding. Judicial intervention is available if assistance of the court has been sought for merely to correct or smoothen the progress of the election proceedings, to remove the obstacle therein, or to preserve a vital piece of evidence, not necessary in my case. The formula here, before the election notification was issued, I have filed a writ petition seeking court's intervention to correct the illegalities, the violation of laws, so that the person who are actually entitled to vote
Long after. Oh, yes. Yes.
I'm sorry, that bylaws judgment needs to I'm just reading that judgment. I'll be handing a copy of that.
What is the
citation is of 2005, 5 SSC 632.
5
Not paragraph 32 and 33.
6 SC.
2005, 5 SCC 632.
Paragraph bolo? Yes.
Paragraph 32 and 33. I'm just reading the relevant part. The fundamental rights in part 3 of the Constitution are normally enforced against state action or action by other authorities who may come within the purview of Article 12 of the Constitution. It is not possible to argue that a person has a fundamental right to become a member of a voluntary association or of a cooperative society governed by its own bylaws, so long as this position holds, we are of the view that it is not possible, especially for a registrar who is an authority under the Cooperative Societies Act, to direct a cooperative society to admit as a member a person who does not qualify to be a member as per the bylaws registered under the Act, nor can a registrar direct in terms of section 14 of the Act to amend the bylaws, since it could not be said that such amendments as directed in the case is necessary or desirable in the interest of the appellant society. What is relevant under section 14 of the Act is the interest of the society and the necessity in the context of the interest. It is not the interest of an individual member or an aspirant to a membership. Then 33, it is blood. Just concluding part, I'm reading that. It is therefore appears to us to be not open to the register or any other authority under the Cooperative Societies Act to direct the society to go against its own bylaws. I'm on this. And to admit a person to membership as against the sought to be done in this case. Here, Malat, the bylaws made a clear distinction: the right of nominal member and right of shareholding members. Admitting nominal members in the list of shareholding members
cannot be done
by an unelected board, by the registrar, by the special officer, by any other officer appointed.
Bylaws do not say so.
No, bylaws made the distinction. Therefore, any appointment by an unelected body, by an officer appointed or nominated board appointed, is that against the fundamental of the cooperative society.
My lord, in moving WPF 4549, I was granted with opportunity by your lordship to make submissions on behalf of the petitioner before my learned senior friend started with his writ petition. However, my lord, certain questions came up from your lordship with regard to the facts of the matter as well as applicability of some points of law. Your lordship wanted to know why and where those persons who were added as respondents in these matters were indeed nominal members, and what was the reason for not granting them with regular membership. This was the factual query from your lordship. As an officer of this court, may your lordship allow me to answer this factual query.
Unless it's an affidavit, no.
As per their application in Can 1
of your application
of my writ petition 4549,
4549
Can 1 application was made by the first lot of party applicants.
Yes.
It has been allowed. It has been allowed. However, the factual answer is there. I'm not opposing this application because it is futile to oppose this application since it has been allowed on the last occasion by your lordship.
Yes. Yes.
Page 32 of this Can application.
Can one.
Which has already been allowed by your lordship.
Can one টা কোথায়?
Can 1, it is the application of first lot of applicants who wanted to be implemented, to be added as respondents in the writ petition being 4549. This was made long ago when the final list of voters was published. In this Can 1, from page 34 to
It is supplementary.
page 32 of the Can application was the same letter of 20th December 2021 issued by the Assistant Registrar of Cooperative Societies, Purba Medinipur 1 range, which my learned senior friend moving his writ petition just now submitted before your lordship. So I'm not taking your lordship's time to resubmit it again. From page 34 to page 51, they have adduced the list of names who were, according to them, ought to have been admitted as members in the cooperative society, who have applied for membership in the cooperative society, and their application for membership could not be considered on positive notes. The reason for the non-consideration was recorded in the meeting of the resolution of the board dated
Page
3rd March 2022, and the reason has not been annexed in their application. It has been annexed in our supplementary affidavit, and the letter that was given to them,
supplementary affidavit to the affidavit in opposition filed by the petitioners against Can 1.
that was filed on the last date,
Yes.
on 27th January.
Yes.
The resolution
Affirmed on
has been annexed at page 5.
affirmed on 27th of January.
Affirmed on 27th of January and
Which
filed at
page?
Page 5. The relevant portions will be the second and third paragraphs of page 6.
Yes.
In second and third paragraph, may I be allowed to place these two paragraphs?
Yes.
And whereas it also transpired that applicants other than already shareholder members have clubbed the essence of Form 28 with that of Form 28B of the 2011 rules, as they have mentioned the names of their intended nominees even before being admitted as members of the society. Now, therefore, it has unanimously been resolved in the special meeting of the board today that these applicants who are not already members shall again be requested in writing and be registered post to receive their application strictly under the prescribed form for membership mentioned above, whereupon the same shall be considered in accordance with law, and whereas the persons who are already members may be informed accordingly. The applicants who made their application in duplicate shall also be requested to resubmit their fresh applications once only. Now, my lord, pursuant to this resolution, the letter that was issued to them has been annexed in that Can 1 application.
Yes.
That is at page 54 of that Can 1 application.
Page 54.
Page
Yes.
54 of that Can 1 application.
Yes.
To one of such applicants, this letter was in specified format. It was issued to all of them.
Yes.
So they have annexed only one specimen that will suffice the purposes.
Yes.
Subject consideration of your application for membership dated 18 January 2021. We are delighted to inform you that we feel ourselves fortunate for being requested by you for membership, as we have received your application for the same in bulk on 18 January 2021. We received yours in bulk. However, please be informed that upon threadbare scrutinizing of your application referred to herein above, the society is constrained to state that the said application prima facie appears as not have been made in accordance with the form prescribed for membership by the rules framed under the statute governing cooperative societies in the state of West Bengal, because it was found that in your application for membership, you have clubbed the application for nomination when the law prescribes two different forms for the said two purposes. You are therefore requested to make your application for membership afresh, strictly in accordance with law, along with necessary supporting documents in terms of the above, so that the same may again be considered by the society in terms of law. Therefore, you are requested to resubmit your fresh application only once. Why this decision was taken and this communication was made? The format for making application for membership in a cooperative society, not in only in our cooperative society, has been prescribed under Form 28.
It was not in prescribed format.
Form 28 is the form which has to be signed by the person concerned, and Form 28B of the 2011 rules is the form which shall be signed by the member, which indicates that upon his admission as member, as per our understanding, it may be erroneous. It may indicate that after admission of an applicant for membership, after grant of membership to him, he may make application for having nomination under that Form 28B. We might have been wrong in our decision, in our threadbare distinguishing analysis of these two forms. However, in our humble submission before your lordship, their remedy would have been under section 64 subsection
Prefer an
4,
appeal.
which my learned senior friends have elaborated before your lordship. They could have preferred appeal before the register. Now I'm not placing that section 64 again. Now what is the law wherefrom it may be derived that the special officer shall not be considered as the person empowered to grant membership, because section 36 subsection 4 clause B of our 2006 Act specifically provides that the special officer shall have all the powers of the board. Your lordship was pleased to ask what was the power of the board. That power is under section 32 subsection 1 is to manage the affairs of the cooperative society.
Duties of the board.
Duties of the board.
What are the duties of the board?
Duties of the board has not been it is under
Yes, show me what are the duties of the board.
মেন্টালিটি নিয়ে তো বলছে এখন মেন্টালিটি দিয়ে তো হলো মেরিট তো হবে আবার
duties of the board is at rule 53.
Rule 53.
Rule 53 of the 2011 rules.
Yes.
The power is at section 32. Duties is at rule 53.
Yes. Yes.
The following duties, the acceptance of members have not been specifically mentioned at one glance in this rule 53. However, this is the statutory rule.
Yes.
Maintain register of members up to date. That is under clause G. Clause G of rule 53. To maintain register of members up to date.
What is the meaning of this? What is the meaning of
The up to date membership means any addition, deletion, alteration that shall have to be
So
made
up
by
to
the-
date membership list, that's also the duty of the board.
Yes. Now, apparently, for the sake of argument, it may appear that by virtue of the power of section 36 4B, the special officer may also be clothed with this power of rule 53 clause G of the 2011 rules. Apparently so. Here, my lord, the Honorable Apex Court in year 2000, volume 6 Supreme Court cases, page 127. That is Joint Register of Cooperative Society.
Mr. Ahmed has stressed that this is
Again, Kerala versus K.A. Kuttappan. Here at paragraph 7, what was the specific observation of their lordships in the Honorable Apex Court? I am only placing that part, the relevant part. Paragraph 7 from page 132 onwards.
Yes.
Page Page 132 from 11th line from the top.
Yes.
May I place minute?
Yes, yes.
Indeed, this court, while considering the provisions of section 30 capital A of the Karnataka Act, which enabled a special officer appointed to exercise and perform all the powers and functions of the committee of management of any officer of the cooperative society, and not merely functions.
Yes.
Not merely functions, took the view that the administrator or a special officer can exercise powers and functions only as may be required in the interests of the cooperative society. In that context, it was stated that he should conduct elections as enjoined under law. That is, he is to conduct elections with the members as on the rolls by necessary implication. He is not vested with power to enroll new members of the society. We may add that a cooperative society is expected to function in a democratic manner through an elected committee of management, and that committee of management is empowered to enroll new members. Enrollment of new members would involve alteration of the composition of the society itself, and such a power should be exercised by an elected committee rather than by an administrator or a committee appointed by the registrar while the committee of management is under supersession.
If the election
So
comes.
this judgment, whether this judgment passed in the year 2000, long before the coming into force of the 2006 Act on 18 January 2011, and in the context of a state legislation of another state, may have any application or relevance in the facts and circumstances of our case, where we are being governed by the 2006 Act, which came into force in January 2011. The judgment of the Honorable Coordinate Bench, certain paragraphs of that judgment has just now been relied upon before your Lordship. I shall place আমাদের এটা judgment টা কোথায় পাবে? না না হুমা বাসু না অজয়টা judgment of Ajay Das. Ajay Das. That copy of the judgment is with your Lordship, as my learned senior friend has just now relied upon some paragraphs from that judgment.
Yes.
At page 2, last paragraph of this Ajay Das, that is WP 266 W of 2019.
Yes.
Dated 15 January 2019.
Yes.
Page 2, last paragraph. The learned counsel for the petitioner refers to a decision of the Honorable Supreme Court in the case of Joint Register of Cooperative Societies Kerala versus T.A. Kuttappan, particularly paragraph 7 that I have relied upon before your Lordship.
Yes.
Nominated and appointed board of cooperative societies or committees of management appointed by the state are not entitled to induct any members as the same member change the nature and character of the society and consequently defeat the cooperative movement. Now, coming below, in that same page, one cannot but notice that an administrative order cannot be used as an indirect route to amend a statute and consequently frustrate a judgment of the Honorable Supreme Court. This paragraph was relied upon. So, the Honorable Coordinate Bench has considered the applicability of the judgment of the Honorable Supreme Court that was passed prior to the legislation of this enactment in the year 2006 in the context of state legislation of a different state. So, this question no longer, in my respectful submission, remains as res integra as to whether the judgment of 2000 may still continue to have its application in our state. Now, so far as the other aspect, so far as the power of the special officer to exercise all the powers of the board, in another judgment,
These do not answer my. I have taken a preliminary point. I say by reason of the fact that already election process has started, all these issues can be decided by the election commission. This court has no jurisdiction. This point has not been answered by anybody. My learned friends are going on completely in a tangential point. Absolutely.
So this judgment is concerned, the very first page, last paragraph. Ruma Basu judgment.
First page, last paragraph.
First
Yes.
page, last paragraph.
Yes.
However, this court is of the clear view that the expression.
First page, last paragraph.
First page, Ruma Basu. Ruma Basu, WP 19167W.
You have given the MAT decision.
WP barely 3 more minutes.
Yes.
In the meantime, election টা হয়ে যাক।
Last paragraph of page 1. However,
Your Lordship, we also have to address the court, Your Lordship.
I will give you time to.
However, this court is of the clear view that the expression exercise all powers and perform all the duties of the board of directors of the society can only mean and be restricted to perform any normal day-to-day functioning of the society and cannot empower the special officer to take a major policy decision as has been done in the impugned order. Now, what was the major policy decision in that matter? My lord, the division bench judgment in this same matter that your lordship was just now considering. Ruma Basu division bench. the division bench,
Judgment you have given.
the division bench
Inform
judgment
us, ma'am.
passed by your lordship, my lord, sitting in division with my lord justice.
Yes, yes.
It was passed by your lordship.
Yes, yes.
In that judgment, it was considered that even allocation of parking lot is a policy decision which a special officer cannot take.
How is
or
it
cannot
relevant?
make. Now, in my respectful submission, in the light of the observation led in the Kuttappan judgment by the Honorable Apex Court, membership, recognition of person as a member, which shall have the potential to change the democratic structure of the society, shall obviously be a policy decision which the special officer may be restrained from taking. Now, my learned senior friends, another contention was that the special officer did a ministerial job merely. The persons were already entitled to be members. The special officer has recognized him as a member. Now, this aspect, only on the point of law, may I say that this aspect is bypassing the law laid down by the Honorable Apex Court. Whereas in my affidavit in reply today, the two affidavits in reply that I have filed today and one affidavit in opposition to the second lot of CAN application of addition of parties, I have annexed the audit report of March 2022. The tenure of the board ended on 16th March 2022. The writ petition was filed on 10th March 2022. The audit
Your
report
lordship will kindly excuse me, my lord.
31st March
I have
2022.
told my advocate on record, after 5 minutes I shall start charging double fees. So, my lord, he has said that now we convene.
Yeah, I won't be that fortunate, my lord. My lord, so far as 31st March 2022, the audit report auditor had indicated that there were 447 members and other nominal members. The auditor didn't raise any objection. So this was the situation when the board ended with 447 members. Now this judgment of Kuttappan, in my respectful submission, came into applicability. And so far as the other aspect is concerned, in one judgment of DC Wadhwa versus State of Bihar, the question came before the Honorable Apex Court in a writ petition under Article 32 as to whether the governor can proceed with promulgation of ordinances one after another by bypassing the state legislature.
To this, why are you citing these decisions?
This decision may be of some relevance subject to correction by your lordship, that the Supreme Court held in that matter that there was commission of fraud on the constitution and it was a colorable exercise of power, as the ordinance shall have to be placed as a bill before the house to be passed when the house shall assemble. Now here, when the special officer has specifically been restrained by the law explained by the Honorable Apex Court to grant membership, then this exercise of considering persons who were not enlisted as members admittedly, that they ought to have been considered as members, since they, as per the decision of the special officer, they were having the eligibility to be considered as members, by not considering their flaw in the applications, is, in my respectful submission subject to correction by your lordship, was simply a colorable exercise on the part of the special officer. এই জাজমেন্টের প্রথম পাতাগুলো কোথায় গেল? So judgment, I am only referring upon paragraph 7 of this 1987 volume 1 Supreme Court cases, page 395. I am concluding here.
Thank you.
Citation
1987
Your lordship,
NC Mehta.
87.
Candidate of NC Mehta versus Union of India.
DC Wadhwa versus State of Bihar.
They need to have make the reply. Today, your lordship cannot conclude this hearing. All the time.
1987 volume 1 SCC, page 378.
Yes.
Only one paragraph 7.
Yes. Yes, Mr. Ahmed.
All that I'm saying today, let them conduct the election. Lordship cannot today decide this issue. But in the meantime, let them not publish the result.
No,
no, it cannot be.
Set aside, entire thing will be set aside.
So grateful.
Court is insisting over the matter.
Well, kindly
Set aside, entire thing. will
abide by the result of the.
Has to be, Mr. Ahmed, all actions are to abide by the result of the. All thing has to abide by the, does it, this is necessary to be said.
Sometimes we have seen that this is not recorded, therefore no, I'll not.
But I'm just giving copies of my judgment cited.
Your lordship,
One thing I tell you, lordship.
Could have been the first maintainability issue. You are all of you
all merits have
trying to argue.
And election goes. The election goes.
Extempo, let it be heard.
Well, kindly fixes a particular, kindly fixes a time.
Yes, next week I am fixing. I will hear all of you.
इलेक्शन तो स्टे करें होक ना चट्टे hearing होक ना इलेक्शन करो स्टे करें
Stop application for addition of party. Please give the numbers. Applications for addition of party allowed.
Or reply. Or reply. Lad, we need your lordship's leave to add those party.
Yes, yes. So, যেখানে addition. I think it's better. Mr. Ahmed, please file that typed copy. Otherwise, it will become lost. Because in the meantime, on the other day, some others will also come. So I think those 547 and
Lordship may
439
not allow them.
all let all be added because 1,000 names will be there, excepting the petitioners. So 45, so 1,000 will be this way and that way. Petitioners and other things will be that. Actually,
Tuesday. Let them, because my election I have to.
on the next week.
Let them conclude their submission on Tuesday.
It will not be concluded, Mr. Ahmed.
I believe.
I think it's on 24th, your lordship.
Will not be concluded. Election matters.
I am also participating in election. Bar council, I have to go there on a district campaigning.
No, I can, if you want, I can post
No,
it on
let them.
Can it be kept after 17th? Any day after 17th?
After 17th, then 24th.
24th.